Mr. Siminya.
Chair and Commissioners, we are set down today for Mr. Ngcuka's cross-examination.
Mr. Vani.
Chair, just a few quick housekeeping matters. My junior counsel, Mr. Santa Pillay, is not with us today. I excuse her because she has to of argument for the review next week, and since we're a bit thin and short of time, she's not with us today.
Yes.
I just thought I'd bring that to your attention.
Excuse us, Chair. If Mr. Vani could at least speak up louder. Some of us are advanced in age. We don't hear
Yes.
very well. Thank you.
Yes, Ms. Moroka, you must bring your hearing aid.
Goodbye.
Well, I express solidarity with Ms. Moroka, and I share the same drawbacks as she does, being in the same category. Can I be heard now?
Yes, you may.
Okay. The one other matter is that of the bundle that we have provided for this morning's session. And I wish to apologize for the duplication in the bundle. It does mean that about half of the bundle has been duplicated, and we apologize for the waste of paper. How that happened, Chair, was in the original list we put up, we itemized the full affidavit of Advocate McAdam, and he had a number of annexes attached to his affidavit. And then we made reference to the different annexes that we were going to be referring to. So when the Commission requested a separate bundle, they were all printed, including a repeat of those annexes, for which we apologize. With the leave of the Commission, I can now commence.
Yes, you may proceed.
Good morning, Advocate Ngcuka. I hope you are doing well this morning.
Before you proceed, may I just remind Advocate Ngcuka that you are still under your former oath?
Thank you. I'm well, thank you very much.
Thank you.
That's good to hear. And you confirm that you're still under oath?
Correct.
So, Mr. Ngcuka, I first want to say to you that on behalf of the families, they recognize the significant contribution that you have made to the liberation of South Africa and the sacrifices that you incurred in that struggle.
Thank you.
I also wish to just give you a sense of what we hope to do this morning. And I firstly want to make it clear to you that we're not here to try and catch you out or to try and trick you up. That is certainly not what our intentions are. This is an inquisitorial process. It's about putting facts on the table and reaching the truth. And if I recall correctly, in your evidence in chief, you said that you supported that process and you would do what you could to assist the Commission.
That's correct.
Yeah. So in actual fact, the bulk of my questions are going to be about clarification and follow-up. The minority of the questions will be in the category of cross-examination. And the way I intend to run this morning's session, or at least my part of that session, is to ask you various questions in relation to your statement that you provided to the Commission.
Sure.
I'll have a few follow-up questions in relation to the evidence in chief, the oral evidence that you provided. And then I will also ask some questions on the documents that we have provided you and your team.
Okay.
So those housekeeping matters out the way, perhaps we can just start with your statement, and I assume you do have a copy of it.
I do.
So let's start on page 7 of your statement, at paragraph 27. And there you speak about establishing the Human Rights Investigation Unit under the leadership of then Advocate Vincent Saldanha. And in that paragraph 27, you set out why it was that the HRIU was not able to make much headway, including the fact that the amnesty process was still underway, and other challenges such as the availability of witnesses and the like. But to be fair to Advocate Saldanha, as he was at the time, and his team, am I right in saying that that unit was only in operation between 1999 and 2000, so maybe about a year or just over a year?
That's correct.
And of course, we can't really expect a unit that is only in operation for about a year, looking at cases, potentially hundreds of cases for the first time, to achieve much in 1 year.
Well, I thought they did a lot, actually.
Yes.
I was satisfied with the work that they did because it was really preliminary work. Yeah.
Pointed out that they didn't commence with any prosecutions, though, so I suppose that's the issue.
No, that was not their mandate.
Oh, is that so? So they were never meant to bring prosecutions?
No.
Okay,
No.
thanks for that clarification. And then let's turn to your next paragraph. That's 28 on the same page. And you say, my inclination prior to receiving the HRIU report. And perhaps I can just pause for a moment. That report, I'm not sure whether it's actually before this commission.
It was attached to the Kalata affidavit.
Oh, I
It was
see.
in the Kalata documents. I saw the report there.
Okay,
In one of the bundles.
we will take a look for it. There were certainly many reports compiled by people like Advocates McAdam and Ackerman. We'll come back to you on that,
Sure.
on that score.
Sure.
So you said your inclination after getting that report was to farm out the investigation and prosecution of these cases to various DPP officers. But this, however, changed after you received that report. And that's when you decided to centralize matters. So why did you prefer centralization after receiving that report?
Well, I wanted to ensure that there was consistency. You see, they identified a number of the shortcomings, which I thought that it would be best if they were handled nationally. So that was really the reason for me to do that.
Right. And actually in that same paragraph, on the next page, you talk about ensuring a coherent and centralized approach, and that consolidation was intended to avoid duplication, consolidate resources, promote efficiency, consistency in decision-making, and enable a coordinated national strategy for those cases.
That's correct.
So in that same paragraph, you mentioned that you then decided that all TRC cases should be brought to the Special National Projects Unit, the SNPU, within the Scorpions. Now, what motivated your decision to move the cases from, I suppose, a unit within the NPA to a unit within the DSO, the Scorpions?
No, that unit was no longer in existence. So once Advocate Pring Ferreira and Advocate Saldana handed over the document, they'd done what they were supposed to do. And so we created, therefore, this entity which had investigative capacity. So that's why they were then given to Advocate Chris Makadam.
Oh, okay. And in fact, that was going to be my next question, which you've now answered, which the NPA itself didn't have investigators,
No.
but the DSO did, so that was a more appropriate home for the pursuit of these cases, simply because the Scorpions had an investigative capacity.
That's correct.
And then if we can turn to the next paragraph, that's paragraph 29. And you point out that the SNPU operated till approximately 2003. It reviewed and worked on those dockets, but it didn't institute prosecutions because the amnesty process had not been completed. Would I be right in saying that perhaps at a policy level that was one of the factors holding you back, that the amnesty process was still running, decisions were still being handed down?
That's correct. And also to add, some of the people who had been refused amnesty, they had challenged that decision in the High Court. And so we couldn't proceed until those processes had been finalized.
Yes. And we certainly saw that, for example, in the PEPCO 3 matter.
Correct.
Yeah. Now, I want to put to you a passage from the book of Mr. Ole Bubenza. The extracts are in the bundle at page, I believe it's 48.
Which bundle, sir? 1 of 2, 1 of 1.
Okay, yes, we apologize for the ocean of paper before you. You probably have a few bundles, but there should be one bundle, which is the bundle for this morning. I think we need to
I don't have that.
double check.
I don't have the bundle for this morning.
With the
These
leave
are the ones you gave me last time we were here.
I see. With the leave of the Commission, can we just ask one of my colleagues to check whether he has the bundle? So that bundle...
Page 48, Advocate Ngcuka.
Thank you.
It is page 48. And the particular paragraph I want to put to you is also in bundle 1. That's the founding affidavit of Lekanyo Kalata. That's at paragraph 104. And in that bundle, and perhaps we can just use this
I'm
one
not
because...
sure. Which bundle are you now referring me to?
So you may look at the one that's just been given to you.
Yes,
I
do.
You can go to page 4.
Page 4, not 48.
I was just pointing out that the full extract from the book are at page 48, but I'm only going to put to you one extract, and that's, if I can refer you to page 4 of the new bundle. At the bottom of the page, paragraph 104.
Yes.
And I'll read it into the record. Mr. Kalata said, it appeared that the NPA devoted few resources to the SNPU. And according to the author, Ole Bubenza, in his 2009 book, post-TRC prosecutions in South Africa. This was because the NPA was concerned that some cases would have to be withdrawn if amnesties were granted, since at that time the Amnesty Committee was still concluding its work. And actually, you've already confirmed that. So let's carry on. And if you turn over to the next page at paragraph 105, however, according to Bebenza, there were many cases in which amnesty had already been denied or not applied for, such as the case against former SAP General Itzhak Johannes Krappies Engelbrecht, in which an indictment had already been prepared by the Diale unit. And I'll just read the last sentence. By 1999, the Diale unit had reportedly already prepared about 20 charge sheets. None of these charge sheets would see the light of day in court. So what Mr. Bebenza says in his book is that, yes, there were some amnesty cases that were still being deliberated on by the TRC's Amnesty Committee, but some had been concluded. There were denials, and in some cases amnesty was not applied for, and he gives the example of General Krappies Engelbrecht. And you may recall that General Engelbrecht, in the 1980s, he was a senior officer, and at a period of time he oversaw the work of Vlakplaas, where Eugene de Kock was also based for some time. So there was an expectation that after the de Kock matter had been concluded, that there would be cases against his superiors. Do you recall the matter of General Engelbrecht?
No, I know about General Engelbrecht. I contest that statement. I don't think it's correct.
Okay. And just, can you elaborate why you disagree?
Yeah, I'll tell you why. Chris gave me a report, and you'll see in all the reports that Chris, which have been tabled, Engelbrecht case is not in any one of those that were ready for prosecution. Anton did the same thing, Anton Ackerman, and none of the Engelbrecht cases appears in all those reports. So this statement from this gentleman, whatever his name is definitely incorrect.
Okay. Well, yes, I think you are right that the case of Engelbrecht does feature in some of the reports, and we will try to highlight where that happens and perhaps come back to you on that. All right, then returning to your statement, in paragraphs 30 and 31, you refer to the creation of the PCLU. You refer to the appointment of Anton Ackerman to head up the PCLU, and that the SNPU staff and its leader, Chris McAdam, they were transferred to the PCLU. Then in paragraph 31, at the bottom of the page, and yes, you do make the point that the PCLU was also mandated to deal with a number of other cases, such as mercenary activities, terrorism, and the like. Then at the bottom of the page, you point out that you directed all cases arising from the TRC process in which amnesty had been refused and not applied for to be classified as priority crimes. At that time, why did you decide to declare the TRC cases as priority crimes?
I thought that would have been self-evident, because these were important cases which needed to be dealt with. And they related to what I would call unfinished business of the past. So, yes.
And if they were declared priority crimes, then would I be right in saying there'd be a better chance that they would receive attention?
Oh, yes.
Yeah. You also point out that in paragraph 32 that the PCLU identified around 21 cases warranting further investigation. Am I right in saying that in those 21 cases there was a view that there were some prospects of taking them forward?
Correct.
At this point, let's pause because in the timeline, we're now in the first quarter of 2003. And can I just refer you to the speech of Thabo Mbeki? The extract that I want to rely on is at page 18 of this new bundle. The full speech is at page 47 of that bundle, but I think we can just look at the extract.
I've got it.
Okay. I think that's at...
Apologies, Chair. Because of the amount of paper, as I've indicated previously, we try not to get ourselves thoroughly confused. Mr. Vani refers to page 18 of the new bundle. Which bundle?
It's the bundle that we all have.
Chair, that's not very helpful with respect. We have a speech here that says 558, page 508, which was given to us this morning. And I'm trying to understand which bundle is Mr. Vani referring to and which page?
Let Mr. Salukazan assist you.
Sorry, dear. Where? But he says page 4.
You switched off your microphones.
Yes, I'm trying to understand, Chair. We've got two of them, so I was trying to understand which one we're talking about.
Are you on the same page now, Ms. Moroka?
I am, Chair. Thank you.
Thank you.
Okay.
You switch off one of the microphones. There's a problem.
Thank you, Chair. So on page 18, there's a reference to the fact that in March of 2003, the TRC's final volume, that's volume 6, was released. And then on 15 April 2003, President Mbeki made a statement to the joint houses of Parliament on the occasion of the tabling of the report of the TRC. So I just want to put certain extracts of his speech to you and then seek your response. I'll try not to put too many. I'll start with the third paragraph on that page. President Mbeki says, "Let us start off by reiterating that there shall be no general amnesty. Any such approach, whether applied to specific categories of people or regions of the country, would fly in the face of the TRC process and subtract from the principle of accountability, which is vital, not only in dealing with the past, but also in the creation of a new ethos within our society." And then the next paragraph, "Yet we also have to deal with the reality that many of the participants in the conflicts of the past did not take part in the TRC process." In that paragraph, he explains why many did not. And at the bottom, he says, "This reality cannot be avoided." And the next paragraph, "Government is of the firm conviction that we cannot resolve this matter by setting up yet another amnesty process, which in effect would mean suspending constitutional rights of those who were at the receiving end of gross human rights violations. Just on that score and putting our legal hats on, would you agree that in the case brought by the Biko family and the Mkhenges, the well-known Izapa case that the Constitutional Court ruled on, and they upheld the amnesty that was in the Truth and Reconciliation Commission, and one of the main reasons was that in the postscript to the interim constitution, constitutional authority for that limited amnesty was provided, but that post the TRC in subsequent years, that would not apply. Would you agree?
Yeah.
So then if we turn to page 19, President Mbeki points out that we have therefore left this matter in the hands of the National Director of Public Prosecutions for it to pursue any case that is normal practice it believes deserve prosecution and can be prosecuted. This work is continuing. However, as part of this process and in the national interest, the National Director of Public Prosecutions, working with our intelligence agencies, will leave its doors open for those who are prepared to divulge information at their disposal and to cooperate in unearthing the truth, for them to enter into arrangements that are standard in the normal execution of justice and which are accommodated in our legislation. I'll skip the next paragraph. This approach leaves open the possibility for individual citizens to take up any grievance related to human rights violations with the courts. Thirdly, in each instance where any legal arrangements are entered into between the NDPP and particular perpetrators as proposed above, the involvement of victims will be crucial in determining the appropriate course of action. And then lastly, relevant departments are examining the practical modalities of dealing with this matter, and they will also establish whether specific legislation is required in this regard. So on the one hand, the President is ruling out another amnesty, but he is talking about arrangements that would need to be made with the relevant departments, including the NPA, to deal with those who had not applied for amnesty. What was your response to the speech that there were going to be special arrangements made to deal with this special class of cases?
No, I didn't think that there will be special arrangements, to be honest with you. Because I thought the President, what he was referring to was that whoever came forward and gave information will be dealt with as we normally deal with cases. If they want to make a special plea, they want to turn as witnesses, those will be the arrangements that will be made in the normal course of our work. So I never thought there would be any special arrangements that would have been made other than in the normal course of our work.
So at that time, because it appeared that it would just be in the normal course, and you've raised typical procedures you find in the Criminal Procedure Act.
Yeah.
That was nothing out of the ordinary. Although, and we will come to it later, but it does appear that ultimately special arrangements for that category of cases was put into place with the amendments to the prosecution policy, which really did single out the TRC cases for different treatment to other cases.
Unfortunately, I can't help you there because I was gone by then.
Yes, no, I'm aware, and we're not trying to attribute any responsibility on your part. You had left. That came a year or so later. But I'm just asking for your view on the matter. that it does amount to special treatment.
No, but it didn't happen. I mean, it just didn't happen during my time. And so I never had the occasion to consider that.
Yeah, I suppose I'm only asking you as an experienced lawyer, a former NDPP, do you make the concession that the amendments put in place a special process for those cases?
I actually didn't read those prosecution policies, those amendments, so I really can't speak to them.
Okay, all right, we'll come to them and we'll go through them in due course.
Sure.
Sorry, Mr. Ngcuka, for the layperson, there are in paragraphs 18 and 19, President Mbeki puts a scenario and then seems to contradict himself. In your own words, what part of this speech do you agree with? Which part do you not agree with, in your own words? Now, as National Director of Public Prosecutions, this is put before you.
Well, I didn't have, unfortunately, Judge, I did not at that time have to apply my mind to what the President was saying, whether I agree or didn't agree with him, because I was never confronted with the issues that were raised in his speech.
Yeah, but now it's put before you.
Well, I have to think about it.
And
I have to consider it. I'll have to consider it, what it really means.
up to now you haven't.
Sorry?
Up to now you
No,
haven't.
there was never a need for me to do so. But you are raising it now to say, can I think about it? I need to think about it. I need to reflect on it. I don't want to shoot from the hip.
Mr. Ngcuka,
Yes,
today. As I recall your testimony, you said that at some point, I forget the year, may have been 2000, at some point, members of your unit were invited to discuss amendments to the policy. And it was your evidence, it might have been Dr. Ramaite, that went to the meeting. It was...
Go ahead.
You can
go ahead,
correct
go ahead.
me now.
No, sure.
It was your evidence that you agreed with them that there was no need for any amendments to the prosecution policy.
Absolutely correct.
Are you able to explain that a bit more as compared to what we know came later, which is that there were, in fact, amendments to the policy which ostensibly arose as a result of the President's speech?
Thank you.
Why did you think there was no reason for any amendments to the existing prosecution policy?
I thought it covered. I thought the policy as it existed, it just covered all the issues that needed to be dealt with.
This is
I thought so.
despite the
But
President's speech.
Yes. Insofar as I'm concerned, I think the President said whoever wants to make arrangements must go to the National Director and make those arrangements. In my view, those fell within the National Prosecuting Authority Act, which says people must make representations. If I find those representations at the time that were worth considering, then we'll look into them.
Okay.
And we may then decide, as I mentioned, that people who will enter into plea bargain, that people will be used as witnesses, or in certain instances, we might decide that maybe we should not bring the charges against those people, given whatever the facts were presented to me at the time. So we'll look into those. So I didn't think that it was necessary to amend the prosecution
And
policy.
that remained your view throughout your tenure?
Throughout my tenure.
And
In fact,
notwithstanding the President's speech in May
notwithstanding the President's speech, because as I read the President's speech at the time, you are still leaving that discretion with the
Right.
National Director.
Right, thank you.
So I was free to do that.
Thank you.
Mr. Bulelani, sorry to take you back a little in time, but since we're still in the early days, if we can go back to the work of the Human Rights Investigation Unit, the HRIU, and I'd like to refer you to a page in your book. It's at page 227 of the new bundle.
227.
227.
Sure.
And I'll just read to you a short extract. Shortly after his appointment, Bulelani set up a working group led by Vincent Saldana, who had served on the TRC, and he went on to serve as a judge in the Western Cape, to review all the cases that had been refused amnesty by the TRC. The group drew up criteria to guide decisions on whether to investigate matters further or to make recommendations for prosecution. Bulelani said he was obliged by law to prosecute where there was enough evidence to make a case, but at the same time part of him asked if it was worth it. I'm just going to pause there. We'll come back to that paragraph a bit later, but the criteria that the HRIU drew up, are you, I don't know whether you and your team are aware whether that's currently before this commission? Is there a list of criteria that we can refer
No,
to?
I can't.
Okay.
I can't recall that. I'm
All
sorry.
right. And I don't think we're aware of that. We will, of course, ask the evidence leaders if they can try to track down those criteria. But since the HRIU did develop criteria to guide decisions, which I'm assuming that do you agree with those criteria?
Yes, certainly.
Okay.
Otherwise, I would have said no.
Right. So if they develop those guidelines or criteria, was there really any need for the subsequent amnesty task team, which was established to propose new criteria, which ultimately saw their way into the amended prosecution policy? And I know this goes into years after you left. But what's
No,
your response to
maybe
that?
let's deal with it now.
Okay.
Because my representatives went to that meeting, attended the meeting, came back and briefed me. And we discussed it, and then we decided that it was, for us, there was no point in us continuing to participate in that process. We did not agree that that is what should happen. But also we can explain in that we were just concerned that some of the people in that meeting were concerned about what came to be known as those 37 cases of the ANC, and that our participation in that process would have compromised us, because we would have had to take decisions whether to prosecute or not to prosecute them. And so we felt that it was not necessary for us to participate. In fact, it would not have been wise for us to participate in that process. Hence, my instruction was, let's pull out of it, and we did.
And can you recall approximately, and I know this is going back many years, and I'm sorry to put you on the spot when you have to recollect after so many years, but approximately when did you give that instruction?
No, after the first meeting. Whenever the first meeting was, probably it was, I think it was in 2003. So after that meeting, when they came back to report what had transpired in that meeting, what had happened, and so we discussed it and we felt, no, it's not a good idea for us to participate in that forum.
Okay, all right. I think. Well, if it was after the first meeting, then we should be able to give you a.
If you can
date.
find when the first meeting was, because that's a meeting that was convened by Mr. Piccoli.
So I'm advised that the first meeting was on the 26th of February of 2004, and that comes from the report of the Amnesty Task Team, which is at page 201 of that bundle.
Whatever the timing is, if that was the meeting that we attended. If that was the first meeting, I can't contest that.
So you then say you pulled your representatives from the process.
Yeah.
And I'll have to ask my colleagues to check whether in fact the NPA was no longer represented in those meetings. And
During my time.
During your time, yes, yes. Now we will only deal with, I suppose, from February 2004
until August 2004.
Until August of 2004.
Sure.
Okay. I asked my attorney that question, and his response is not clear. So we don't know either.
Okay.
Let's continue, and we will come back to the topic dealing with the process leading up to the amendments a bit later, but just to mop up a few other matters. And I'm returning now to page 9 of your statement.
Okay.
You talk about the fact that at the end of 2002, this is your paragraph 33, beginning 2003, you reported to Parliament that there were some cases emerging that were ready to proceed to prosecution, while others were still waiting rulings from the Supreme Court of Appeal and the Amnesty Committee. And in fact, we do know from the evidence that Anton Ackerman has already put before this commission that there were a small number of cases that did go ahead. For example, the prosecution of Eugene Terreblanche, the prosecution of
Nevote.
Of the PEPCO 3 Nivert, exactly, although that stalled for reasons we're aware of. Another example is that of Ronnie Bulelani.
Yes.
You're familiar with
Yes,
that
I am.
case? Yeah. But according to Anton Ackerman, the only reason why he could proceed with that small group of cases, there were 1 or 2 others after you left. I think in total, was 6 is the number that we have. But the reason that Ackerman put up as to why he could go ahead with those cases is that they were already investigated.
Correct.
They didn't require further investigations. So the ones that could go ahead did go ahead. Do you agree with that?
I do.
Yeah. And I want to put to you another passage from the book by Ole Bubenza. And this is at page 7 of your bundle, this new bundle. As mentioned, there are several pages from his book next at page 48, but we'll just stick to the passage on page 7 at paragraph 114. And so there, and I'll read it into the record, Bubenza noted that while the De Oliveira unit of the 1990s constituted a well-equipped team of experienced prosecutors and investigators with strong political support for the TRC-related prosecutions after 1998 declined drastically. What's your response to that observation by the author Bubenza?
No, I disagree with him. When he talks about political support.
Okay.
If he talks about the support that I gave to the TRC cases, if he refers to that as political support, then he's wrong, because I set up 2 units. First, the Vincent Saldanha unit to look into those cases, and followed by the Macadam And then I brought the one who I consider to be one of the best prosecutors to look into those cases, Anton Ackerman. So that must give you the indication of how serious I took those cases. And Chris Makatam was one of the best prosecutors, and he had delivered for us in KZN, where he had to deal with serious cases of political violence. And so appointing him to that position was an indication by me that I'm taking the best to deal with these cases. So that's proof that there was. If he's talking to that, but if he's talking about political support as political support from government, I don't know what he's meaning by that.
But would you agree with Mr. Bebenza in at least one respect, where he says that the Dodavera unit of the 1990s had experienced prosecutors, and here's the nub, and investigators. Now, you took the step of finding the best prosecutors you could locate in the form of Ackerman and McAdam, and I think we would agree with you. But is Mr. Bebenza not correct that at the PCLU you didn't have investigators, let alone experienced investigators?
Well, Chris McAdam's unit, they had 4 investigators, experienced investigators. They had 2 researchers in that unit. And that is the unit that Anton inherited. And one of the guys who was leading that was a guy called Andrew Lisk. He was the CIO. Andrew Lisk.
Andrew Lisk.
And was a very serious senior investigator. So Anton inherited that unit that had that capacity. So Chris Makatam was working with those people.
Right. So you were talking about the SP
That's
NU,
correct.
which at
Which
the time
was then
was at the DSO.
Yeah.
Yes. There is evidence on record that Mr. Andrew Lisk was not transferred over to the PCLU. He remained in the DSO.
Yeah, that's correct. But in the DSO, remember this case started in the DSO. When Chris Makatam was there, he was working in those cases together with those investigators, the SNPU, whatever that abbreviation is. He was working together with them. That's the point I'm making.
Yes, indeed. But if we now fast forward to the creation of the PCLU, because as I understand it, you appointed Ackerman to run it, and then you brought McAdam over.
That's correct.
The only thing is that Andrew Lisk did not come over to the PCLU at that time.
Yes, that is correct. When Chris took over, well, there were, of course, challenges later dealing with the issue of the investigators. We can deal with that if you want us to deal with it now.
Yes.
Well,
Well, actually, before we get to the investigators, because that is an important issue, Chairperson, I note that it is
Yes.
just gone 11. Is this an appropriate time for the adjournment?
Yes. We'll take a tea adjournment until 11:20.
As the Commission pleases.
Mr. Vani.
As the chairperson pleases. Mr. Ngcuka, just before tea time, we were about to talk about investigations, and I had to interrupt you. But perhaps we can kick off that discussion by looking at some of the paperwork dealing with the cases and how the special national projects and then ultimately the PCLU wish to take these cases forward. So I'd like to refer you to a letter. It's styled internal memorandum. It's at page 102 of the new bundle. I'll just wait for you to find it.
Sure. Correct.
Oh, great. So you see it's from the head of the Special National Projects Unit. That would have been Advocate McAdam. It's addressed to yourself as NDPP, and it's copied to the head of DSO, head of operations, as well as Advocate McAdam. So what's interesting about this memorandum is that it sets out a number of cases that the SNPU was working on. Indeed, it's titled Audit of TRC Cases. It's under various categories. And I think it might have been this letter that you were referring to earlier. But you correct me if I'm wrong. So, for example, the first title, first heading, cases being prepared for prosecutions. And there are a number of matters there, Motherwell prosecution, Motherwell bombing, prosecution of SAP General van Rensburg for ordering the killing of Brian Ngulunga, PEPCO 3, which we've referred to earlier, and there are others that I won't list. And then there's another category, potential further prosecutions arising from the above, and that includes PEPCO 3 and Craddock 4. Then the next heading, C, new cases being evaluated for prosecution purposes. A number of cases there, 7. These include, for example, the murder of the COSAS 4 and the murder of Askari strongman Sambo. Then D, the high interest cases which require attention irrespective of the nature of the available evidence. Murder of Victoria Mchenge, your former boss. Other well-known cases, Kubeka, Mokotula Simalani. I'll just highlight the 4. A decision by DPP Pretoria not to prosecute SAP General Engelbrecht, because you mentioned, we spoke about General Engelbrecht earlier. Uninvestigated allegations against SAP General Basi Smith and others. And then there are various other headings as well, representations to investigate specific cases, also some well-known cases there, death and detention of Ahmed Timol and others. Cases in the process of being closed, some well-known cases, I'll highlight number 5, Steve Biko, crime prescribed in 1997. So this is an indication from the head of the SNPU that they had a number of matters that were on their books, cases that were actually being prepared for prosecution, cases being potential further prosecutions, and cases being evaluated. So it looked like quite an encouraging document, and I imagine that when you read it, you would have been satisfied with what the SNPU had done.
That's correct. Now,
As we sit here today, I must put to you that a number of these cases, some of them very well-known ones, as we sit here today, remain unresolved. So, for example, Craddock 4, that case is still before a third inquest. PEPCO 3, that prosecution never happened, and there's only an attempt now to get an inquest going. COSAS 4, I'm pleased to advise there have been indictments in that matter, but only in 2021, and that case has not proceeded for various reasons. Strongman Bambo, this commission has heard the evidence of Andrew Leask in relation to that matter, and that has also not gone ahead. So I want to put it to you that notwithstanding the promising start, that virtually all these cases did not see the light of day as we're looking back into history now. And yes, I know that you left office not long after this, but I just want your view, your feelings about that.
Oh, obviously, I mean, it is regrettable. That is what has happened. Obviously, it's something that I don't like. And so, yeah, I don't feel good about it.
Yes. And on that score, we certainly share your feelings. So I want to put to you a passage.
Sorry.
Yes, yes.
If you look at this memorandum,
Yes.
you will see nowhere does it say, in cases that are ready for prosecution, that General Krippes Engelbrecht, you don't see his case there as being ready for prosecution, which is the point I made earlier on.
Yes, and that's why I highlighted for your attention.
Yes.
It's sitting under high interest cases which require attention irrespective of the nature or the availability of evidence. Yeah. So I want to put to you a passage in the Kalata affidavit. It's at paragraph 132, and let's just stick to the current bundle. It's at page 25.
You said page 132 or
No,
paragraph?
I'm going to read you the paragraph 132.
Sorry.
And it's at page 25 of that bundle. So Mr. Kalata says in that paragraph, if only a fraction of the cases listed in McAdams' report had been resolved in the early 2000s, it would have brought significant closure for the concerned families and given considerable impetus for the finalization of the balance of the cases. Do you agree with that statement?
Of course, yes.
Then let's, while we're on that page, paragraph 133, reference is made to the minutes of the Justice Portfolio Committee meeting on the 10th of June 2003. There's an extract there, but the actual minutes of the Portfolio Committee meeting, I believe, are in the same bundle at pages 178 to 180. So I just want to read that short paragraph and ask a question arising. And I understand it. So you were present at this meeting of the Justice and Constitutional Development Portfolio Committee on the 10th of June 2003, and I'm reading from the minutes put together by the Parliamentary Monitoring Group. The exact extract is on page 180, but it's also reflected here. Some cases emerging from the Truth and Reconciliation Commission are ready to proceed. In others, the NPA awaits rulings of the Supreme Court of Appeal and from the reconvened TRC Amnesty Committee. The Chair interjected to ask if any legislative change was needed to deal with TRC cases where immunity from prosecution was to be afforded. Mr. Ngcuka replied that he could see no need for a change in legislation. So, firstly, what was the immunity from prosecution that was being referred to in this passage?
That probably was, 26 years. I don't think I can correctly recall what he meant, but I would imagine that it was speaking to the issue that we discussed earlier on, whether there was a need to amend the prosecutorial policy to grant amnesty to those people who had not applied. So I would imagine that's what he was referring to. But as you can see, my position has been very consistent since then. I saw no need then, I see no need now to change any legislation to deal with those cases.
So that goes back to the President's speech, President Mbeki's speech in May 2003.
That's correct, Commissioner.
Well, we will return to this a bit later, but from what I hear you saying, the normal processes in the Criminal Procedure Act could be invoked, so there was no need to come up with a brand new law.
That's correct.
Yeah. So then let's then turn to the issue of actual investigating officers. And if we carry on the next paragraph, reference is made to the fact that at the DSO it was Special Director Advocate M.G. Jeff Ledwaba who made decisions on the opening of new investigations.
On which page are you, Mr. Vani?
So I'm still in the Kalata Affidavit, page 25. It's the next paragraph,
Yes.
134.
Yes.
So it was Ledwaba who made decisions on the opening of new investigations. Accordingly, Ackerman and McAdam met with Ledwaba to ask the DSO to conduct investigations referred to in that report we've been through. And it appeared that Ledwaba was firm in his refusal to take on the TRC cases. So I just want to highlight a passage from Advocate McAdam's affidavit, and that's at page 89 of the bundle. And the paragraph in question is on page 92. I believe is that paragraph starts at paragraph 18.
Page 92.
Yeah, I think the reference is at this paragraph is at page 92.
Sure.
And just so you know, this is an affidavit that that Advocate McAdam put up in litigation arising from the Ahmed Timol matter, when Jean Rodriguez, a former security branch officer, was charged with the murder of Ahmed Timol. The affidavit is dated the 1st of November 2018, and it was put up as part of the NPA answering papers. So at paragraph 18, McAdam says, in terms of the DSO legislative mandate, it was for the special director of the DSO and not the head of the DSO to issue declarations to investigate certain matters. At that stage, the special director was Advocate M.G. Ledwaba. And in paragraph 19, he writes, Ackerman and I met with Ledwaba to arrange for the DSO to conduct the investigation specified in Annex RCM2. That's the memo we've just been through. He says the meeting was unpleasant, as Ledwaba made it clear in no uncertain terms that the DSO would not investigate any TRC matters and that these should all be referred to SAPS. Can I assume that at that time, Advocates Ackerman and McAdam would have been keeping you abreast of these developments?
Yes, but at a later stage.
At a later stage, okay.
Just remember that Advocate Ackerman reported to Silas Ramaite, not to me.
Yes.
So I get to know some of those things when there were problems which they could not resolve.
Okay.
So it would probably not have been at the same time
Right.
when
So
this happened.
there might have been a bit of a lag in time.
That's correct.
When you heard that Ledwaba, in the words of McAdam, was making it clear in no uncertain terms that the DSO would not investigate any TRC matters, what was your response or your reaction?
We'll come back to that later, but at that time, Anton and McAdam, they went to the police to ask for the investigators. And so I'm not aware of this at the time. I only got informed after they were rebuffed also by the police. And so it is at that point when I then called Leonard McCarthy, was the head of the DSO, and Ramaite to say, come on guys, resolve these issues. If that is the attitude of the police, the DSO must investigate these cases. So I said they must resolve whatever issues they had. So I left it at that at the time.
Okay. According to the timing or sequence, at least on the versions of McAdam and Ackerman, it appears that they first approached the DSO. When the DSO refused, they then turned to SAPS. So we may as well look at McAdam's next paragraph. That's paragraph 20 at the bottom of the page. As a result of this decision by Ledwaba, Ackerman and I met with Commissioner De Beer, the divisional head of the detective service of SAPS, and requested SAPS to take over the investigations. On 26 September 2003, De Beer replied to Ackerman, informing him that the request had been discussed with the National Commissioner, Selebi. The letter was further to the effect that the investigation of the matters was a DSO responsibility, and that if it was required that SAPS in fact investigate, then either Ackerman or the NDPP should approach the President and ask him to confirm which agency should conduct the investigations, and he attaches a copy of that letter. Just to wrap it up from the side of McAdam, he says he can confirm that neither the NDPP nor Ackerman approached the President. I do want to return to that, and we'll come to it because you actually deal with that in your statement and you give a comprehensive answer. But before we get there, let's turn to the next document. And this is, if we can go back to the Kalata affidavit. My colleagues will have to tell me. We're at page 135 of the Kalata affidavit, and that is page 135. page 26 of this new bundle. So there, a reference is made to a letter addressed by Ledwaba to Andrew Leask. Andrew Leask was, I understand, the Chief Investigating Officer at the DSO. It's dated the 15th of July, 2003. And this is at page 107 of the bundle. And on the first page, there's a section titled TRC Cases. So this letter is from Advocate M.G. Ledwaba. It's to CIO Leask. I assume CIO means Chief Investigation Officer.
Correct.
It's titled SNPU Investigations, and we'll just focus on that very first entry. He writes, due to the recent creation of the PCLU, it has become necessary to redefine the mandate and operations of the SNPU as follows. Roman numeral 1. I have decided that SAPS must take over the investigations of all such cases handled by you. Your files should be closed off and all the material given to the PCLU. Now, I raise this because a bit earlier you had mentioned that Andrew Leask was the officer who was either with the PCLU or working with them to investigate these cases. So can you see, Mr. Ngcuka, that at least by the 15th of July, Andrew Leask was specifically ordered to close off all his files, hand them over to the PCLU in relation to the TRC cases?
Oh, yeah. Sure.
Yeah. So then I want to put to you a passage in the Kalata affidavit at paragraph 136. I believe that's at page 26. And the passage reads as follows. The refusal of the DSO to investigate the TRC cases was a remarkable decision, given that the DSO had previously been seized with the TRC cases, and just weeks earlier, the NDPP had declared the TRC cases to be priority crimes. What's your response to that passage?
I don't know if I can classify it as remarkable. The unfortunate part is that I can't recall what the reasons were that Ledwaba had advanced for taking that decision. But certainly he had not consulted me. And I wasn't aware that's the decision that he had taken. I became aware of it much later. And as you will come to realize, I sort of reversed that decision.
So were you in a position to order the DSO to take on those cases?
Yes.
And when you say you reversed that decision, approximately...
I instructed, you'll see later when we come to it. When the guys came to me, they would say, look, we have exhausted all these avenues. We need the investigators. We need these cases to be investigated by the DSO, not by the SAPS. I declared that, and I instructed the DSO to investigate the cases.
Yes, okay. My attorney, I think, has found that passage, but as you say, that's a later development. That's later in the year, in November, so we will...
When we remember...
Yeah, we will come to
There was a process before we got to that.
Yes, indeed. So developments in the interim. So now you have the situation where Ackerman and McAdam are told that they must knock on the door of the SAPs. And so an overview of those attempts are set out also page 26 of the Kalata affidavit from paragraph 137. If one looks at Ackerman's affidavit, if we go back to page 92, and apologies for all the up and down in the pages, but that's unavoidable. In fact, we have dealt with paragraphs 20 and 21. So they had this meeting with Divisional Head of the Detective Services, Commissioner Johannes de Beer, and essentially they told them, I'm not going to repeat what's in paragraph 20, but perhaps let's take a look at the letter that de Beer addressed to the NPA. And I believe that letter is at page 296. Sorry, it's at 109 rather. So that is a letter from Commissioner de Beer addressed to Advocate Ackerman at the PCLLU. I'm not going to read the entire letter into the record, but just starting at that first paragraph. I have discussed your request for the assistance of the SAPs to investigate cases emanating from the TRC processes with the National Commissioner. It is evident from your letter that the investigation and prosecution of these cases were referred to the NDPP by the President. Our understanding was that this referral was politically inspired. As you know, a large number of cases to be investigated are those of ex-policemen. It is therefore understandable that you first endeavoured to have these cases investigated by the DSO. And then I'll just skip some paragraphs, go to the next page. In view of the nature of the investigations, the fact that the President has referred it to the National Director, and that it seems to be common cause that the initial understanding was that the DSO would have investigated, the opinion is held by you, or the National Director should approach the President to confirm the instruction of the President on who he wants to investigate these cases. Then he finishes off, if the President indicates that SAPs should be involved in the investigations, the instruction should be obtained in writing. So that is quite a remarkable letter where you have an agency that is empowered under the Constitution and under law to investigate serious cases like murder, saying to the prosecutors at the PCLU, we won't investigate this because we think it should be investigated elsewhere. And if you want us to investigate, then we want you to get an instruction from the President in writing. What's your sort of gut reaction to that?
Well, I do deal with that in my statement. I thought it was unfortunate that Commissioner Adv took that stance because the President had made it clear what should happen to those cases. And it's in the nature of the work that we used to do that there was cooperation between us and SAPs. We work very closely with them. whatever the nature of the investigation was, whenever we appealed to them for assistance, they would ordinarily assist. If you take, for example, that unit you call the Toliveira investigating unit, all the investigators there came from SAPS, and I inherited that unit. You talk about most of the investigators in the DSO themselves, they came from SAPS. So I just thought that Commissioner Diale, the language that he used and what he was saying there was very unfortunate.
I think you used stronger language in your statement. You said this demand by Commissioner Diale was, with respect, nonsensical.
That's correct.
Do you want to elaborate on that?
Well, I thought I have. I just didn't want to use that language today.
Okay, all right. My apologies for raising it then. And I must say, I would have some sympathy with you because, and if I can use the word, it is a nonsensical response. And one even might go so far as, how dare the head of detective services say that he won't investigate murders, and he's already been told that the only other investigating agency in the country that could deal with it, the DSO, says they won't. Then one would really have expected the SAPS, because they have considerable resources, perhaps much even larger than the DSO, and they're required under law and under the Constitution to investigate serious crimes, murders, kidnapping, and the like.
Yeah.
So there should have been no need to go get a higher authority in the form of the President to instruct the police to do their work.
That's the point I made.
Well, we're in agreement there. But can I put this to you? On the one hand, it does seem nonsensical to have to get an instruction from the President to tell the SAPS to investigate. But on the other hand, just to break the impasse, wouldn't it have been advisable on your part to have said, well, I don't have to do this, but just to break the impasse and get the cases off the road, I'll approach the President?
Oh, no. The President would have laughed me off and would have thought that I'm foolish. And I didn't want to appear so.
Right. Well, the unfortunate outcome is that the impasse then remained. You do say in your statement and in your evidence that you directed Advocate Silas Ramaita and Advocate McCarthy to resolve the issue. Are you aware whether they did, and if so, what steps they took?
No, I'm aware that they did not resolve the issue.
Yes.
They complained, the DSO complained about not having enough investigators. And also that they were working in teams and that it was very difficult to break up the teams because they were engaged in a number of very serious projects. And so, unfortunately, I then had to intervene and direct that they must investigate these cases, which would have been unnecessary.
Yes, so we put that question to Advocate Ackerman when he testified before this commission last week. We put that statement at paragraph 43 of your affidavit, and he said he wasn't aware that Advocates Ramaita and McCarthy had been directed to resolve the issue, but as far as he was concerned, it was never resolved.
No. Anton's memory is a bit failing him. He knew that.
Okay.
He knew. Anton was coming to my office regularly to talk about the frustrations that he was having. And so when they could not resolve that issue, he, Anton, drafted that directive. You will see the directive there that I signed. It's not even in the National Director's letterheads. It's in the letterheads of the PCLU. They drafted it and brought it to me. He did that, and I signed it. So he should have known that is what happened afterwards, that when I made that declaration. So I think he just forgot it.
Yes. Well, to be fair to him, he also gave evidence on the declaration, so there's no disagreement there. He was part of that process to try and get those declarations signed. But perhaps let's move on. I just want to put to you certain passages arising from the Diale letter, and I believe it's at page 27 of the new bundle, the 3 paragraphs at 139 to 141. Paragraph 139 reads as follows. Paragraph 139 on.
Thank you.
I think it's page 27.
28.
It's
28. My apologies. I'm actually working off bundle 1. It was at a time when I didn't know that we would have a fresh bundle. At page 28, paragraph 139. It is notable that SAPS regarded the TRC cases as a political issue. It is also noteworthy that the only state entities authorised to conduct official criminal investigations in South Africa both refused to touch the TRC cases. It is highly unlikely that their decisions were spontaneous or mere coincidences. It is apparent that by May 2003, both the SAPS and the NPA were reluctant to take on the TRC cases, in all probability being told not to do so from a political level. Your response?
That's incorrect.
And then the next paragraph. The fact that the NPA was told to contact the President reflected that the question of investigating the TRC cases was now a purely political one and a sensitive one at that. It appeared that only the head of state could make that decision, regardless of what the law and Constitution said about investigative authority. Your response?
No, but I've already dealt with that,
Okay.
Mr. Ghani.
All right. And to be fair, you've also dealt with the next paragraph, so I won't put that to you.
Can I just take you back to paragraph 139?
Yes.
The last sentence where the deponent says, and in all probability had been told not to do so from a political level. You say that was incorrect. What are your reasons for that?
Well, I was never
answer?
told. I was never told
So you don't.
not to take these cases.
You were never told.
No, nobody said I mustn't take the cases. That's why I'm saying that's wrong.
Okay. So that is why you say the
point,
statement
the
is
person
incorrect.
who would have been told at a political level not to deal these cases is me. Would have been told by the Minister of Justice or the President, whoever. And that never happened.
No, I think
That's why I'm saying the statement is wrong.
Yeah, I think the deponent is saying that SAPS and the NPA were reluctant to take on the TRC cases. And in all probability, they had been told not to do so from a political level. Yeah. Now, do you still maintain that that sentence is incorrect?
Yes, that's what I'm saying. That we're never told that.
They
So
were
that's
never
it.
told that, or you were never told that?
Well, I was the head of the NPA, madam.
You were never
Yeah,
told that.
I was never told. So the NPA could only have been told through me.
Okay, but you don't know what had been told to SAPS.
I don't know what happened in SAPS.
All right. Thank you.
Thank you, Commissioner. And then if we just continue the unfolding story, and also on page 128, paragraph 142. Thereafter, Ackerman and McAdam made a last-ditch attempt to persuade Special Director Led Waba at the DSO to reconsider his decision not to investigate the TRC cases.
I'm sorry. I'm sorry, I'm not with you.
You're not with me? So it's page 28 of the new bundle?
28.
Yeah.
Sorry, not 128. Okay. Yes. And paragraph?
And at the very bottom paragraph,
Paragraph 142.
Correct. Thanks.
paragraph 142. Thereafter, Ackerman and McAdam made a last-ditch attempt to persuade Special Director Ledwaba at the DSO to reconsider his decision not to investigate the TRC cases. Ackerman sent Ledwaba a letter styled as an internal memorandum dated 11 November 2003, appealing him to appoint investigating officers. And I think let's actually go to that letter. It's at page 111 of the bundle. So as you can see, it's from Ackerman to Advocate Jeff Ledwaba. The parties copied are yourself as NDPP, Dr. Ramaita, as well as Advocate McCarthy. It's titled Investigation of TRC Cases by the DSO. It's a fairly long letter, so we'll try not to read everything into the record. It starts off, Dear Jeff, in the light of current developments, I'm constrained to document the history of the above saga. And in that first paragraph, he sets out the background. We've been through that background. I'll just highlight Roman numeral 4. In May 2003, I gave the NDPP and his duties a full briefing on all TRC cases identified for prosecution. He says, my prosecution strategy was endorsed, and Advocate McCarthy indicated that there would be no problem in having the cases declared in terms of Section 28 of the NPA Act. The NDPP briefed the Minister and Justice Portfolio Committee accordingly. Shortly thereafter, this is Roman numeral 5, and in the same month you were presented with applications in terms of Section 28 relating to the cases. In July 2003, you verbally informed me that you were not prepared to sign the declarations and you were withdrawing the DSO from the further investigation of the cases. A letter to this effect was given to the CIO, leased by you. In response thereto, I requested Commissioner De Beer to appoint the police to take over the investigations. Okay, we've dealt with that, so I'm not going to read it in, but we know the outcome of that. We needed presidential instruction. Roman numeral 8. After receipt of De Beer's letter, I made several unsuccessful attempts to contact you to discuss the matter. Eventually, I had to report the matter to Dr. Ramaita. Roman numeral 9. On 3 November 2003, you informed me that you would sign the declarations in terms of Section 28(1)(b and would appoint SSI De Lange to conduct the necessary investigations. Roman numeral 10. On 6 November 2003, Dr. Ramaita informed Advocate McAdam that he had discussed the matter with Advocate McCarthy, who indicated that the DSO would investigate. On 10 November 2003, McAdam presented you with the Section 28(1)(b) declarations. You informed them, A, that you are not prepared to sign any declarations, B, De Lange would not be appointed despite the fact that it was explained to you that he was part of the initial investigation and familiar with all the witnesses and the facts of the cases, C, that during the course of 10 November 2003, another investigator will be appointed, D, the President should not be approached to involve SAPS. Paragraph 2 is at the date of this letter, I've heard nothing further from you. I'm constrained to express my concern at the above state of affairs. Since July 2003, no investigations have been conducted. And then he sort of expresses his alarm in the next paragraph. There are certain cases which could have been prosecuted which have prescribed. There's both national and international pressure to institute prosecutions, for example, Bulelani's case. An amnesty hearing for the Motherwell matter has been set down for early March 2004, and the TRC was given an undertaking that certain investigations would be conducted and made available to the committee. He then raises concerns around availability of witnesses and high public interest, that the other cases will be brought to trial as soon as possible. He says the failure to do so will bring the bona fides of the NPA into serious dispute and do irreplaceable damage. Since I do not have any investigative capacity, I'm powerless to deliver on my mandate. For the sake of justice and expediency, I appeal to you to assign De Lange and another investigator to investigate these cases and to sign the declarations in terms of Section 281B. This chapter in our country's history must be closed without further delay. So would you agree that there's a sense of desperation with McAdam and the PCLU, and that he's now pleading with Advocate Ledwaba to change course?
That's correct.
And you were copied on that letter, so at the time you would have been familiar with it.
Yes. But let me just say this.
Yes.
It's not an excuse, but it's a fact.
Yeah.
At the time these things were happening, the NPA was going through a very, very difficult time. For example, that November, I was busy with the Khampepe Commission in Bloemfontein, where I was dealing with the allegations that were made against me by Mo and Sheikh and Mek Maharaj that I was an apartheid spy. That was one. Two, I was dealing with the case of the arms deal matter involving the deputy president at the time. Three, I was also dealing with the case of the late Brett Gabriel, who had hired a journalist to write nasty articles about me almost every week in the Business Day. Four, I was dealing with serious attempts to discredit the Scorpions by senior members of the ANC, including the Secretary General thereof. And so I'm dealing with all these matters at the same time. So you're talking to somebody who was not just sitting at the office and waiting for a command. And in a sense, I was frustrated that these guys are not dealing with these issues that they should be dealing with. Because there I was defending the organization from all the attacks that it was getting. And some of you may be old enough to remember that there was a period in this country when my name was in every newspaper every other day because of the work that the Scorpions were doing. So I was busy defending the organization. And I expected my juniors to be able to deal with these matters. So there was a sense of frustration from me too, that we were not able to resolve this. But I want you to understand the context or the period in which we were living at the time when these matters were happening. Thank you.
Yes, and we accept, Mr. Ngcuka, that you were carrying a lot on your shoulders. You had a lot on your plate. And I think we should place on record that the allegations made against you were fabricated allegations. But nonetheless, what was set out in the letter, would you agree that was not an unreasonable request?
No.
And in fact, he wasn't asking for huge resources.
No.
He was asking for one detective by the name of De Lange and one other. So he was only asking for 2 investigators.
Yes.
So I then want to go back to the Kalata affidavit and just put certain passages to you to see whether you agree with them. So that back in the Kalata affidavit at 143, actually it's at page 31 of the new bundle. Ackerman's heartfelt plea fell on deaf ears. Ledwaba was not moved to act, even though he was advised that the NPA was under local and international pressure and cases were prescribing. Ackerman's warning that the failure to proceed with the TRC cases would bring the NPA into disrepute and do irreparable harm to its image was precisely what happened. Do you agree with that passage?
Yeah, no, that's correct.
And in the next passage at 144, the DSO persisted in its refusal to appoint investigators, as did the SAPS. According to McAdam, this effectively brought an end to the TRC cases, as it meant that no new investigations of the TRC matters could be opened. And 145, the TRC cases were effectively closed down before the end of 2003, before the PCLU could commence real casework. The few cases taken forward subsequently were those in which investigation dockets had already been completed, and we've discussed that. So do you agree that McAdam appears to be saying that effectively before the end of the 2003, they were stopped from taking what we can call the uninvestigated cases forward because SAPS and DSO were not providing investigators?
No, I don't agree with that. I don't agree. That is incorrect.
Okay. Can you elaborate?
That is incorrect. Because I have told you that after he was unsuccessful with Letaba, they then came to me. And then I ordered that those matters be investigated. I made that order. And not only did I do it once, I did it twice. In respect, the matters that were brought to me in December, the others that were brought to me in February. So it can be correct.
Why did you order twice?
The separate matters.
Separate matters.
Separate matters, yes.
So we're just struggling to find where you ordered the DSO to investigate. Is that reflected somewhere in a document?
You will find it in the. I think it's in the McAdam affidavit.
So, do I understand your evidence, Advocate Ngcuka, to be saying that TRC cases were not effectively closed down before the end of 2003?
Absolutely correct, Commissioner.
Same thing. Yeah, okay. So I think we have found a document we'd like to put to you. And I'm advised that it was attached to McAdam's affidavit before this commission. And that is not part of the bundle, but perhaps would my learned friends be willing to share that bundle with the witness? Yeah. Can you give it to? Were these cases actually investigated?
Thank you.
Yes. Commissioners, I don't know whether you have access to the statement by Advocate McAdam before the Commission. It's his affidavit. This looks like an unsigned version that was signed on the 3rd of March of 2026. I thank my colleagues for making it available. We just wish to refer
How
to
much?
two internal memos.
815. 815.
So the first one is an annex to that McAdam statement before this commission. It's from the head of Priority Crimes Litigation Unit. It's from the NDPP to the head of Operations, DSO. It's dated 8 December 2003. Of TRC cases by the DSO, and it reads, I have decided in terms of Section 28(1)(b) of Act 32 of 1998.
Apologies, Chair. Where are you reading it from? We've got the document, Mr.
You're not audible.
Apologies, Chair. I'm saying, Mr. Vani is referring to this document that's just been handed up, and I was
Yes.
just asking for pages.
815.
Thank you.
To be fair to my learned colleagues, this particular statement of McAdam is not part of the bundle that we have put up.
Yes, but
So
it
that's-
has been handed up to us.
Yes, it has been handed up to you. I don't know
Yes.
whether a copy has been handed up to them.
Yes, it has.
Okay. All right, then I'll carry on. It's Annex AD 13. I'll carry on reading. I've decided in terms of Section 28(1)(b) of Act 32 of 1998 that the following three cases arising from the TRC be investigated by the DSO. 1, kidnapping, assault and murder of the PEPCO 3. Murder of Brian Ngcuka. 3, murder of Motherwell 4. And 4, attempted murder of Reverend Frank Chukani. It's signed by the NDPP, Bulelani Ngcuka, dated the 24th of February 2004. Now there does seem to be a difference in the dates between the signature and the date on the top. But do you confirm that you signed this letter
I do.
authorizing those
I do.
4 investigations?
I do.
And then we want to put
How
another
do
one.
you explain the discrepancy, Advocate Ngcuka, to the date reflected in the internal memorandum being the 8th of December 2003, and the one reflected below your signature being the 24th of February 2004?
I suppose the 8th will be the date when it was prepared,
Okay.
and then the 24th was the date when it was approved,
Yes, when you signed it.
when I signed it, yes.
And then the other one we want to put to you is over the page. It's at Annex AD 15. It's from the Office of the NDPP. And it's addressed to Advocate M.G. Ledwabe, Head of Operations. And it's dated the 26th of February 2004. It's also titled Referral of TRC Cases to the DSO in terms of Section 28(1)(b) of Act 32 of 1998. And it reads, I've decided to refer the following matter to the DSO for investigation in terms of Section 28 of Act 32. Crimes of murder, attempted murder, conspiracy or incitement to commit murder committed in an organized fashion by Letlapa in Plashlele with reference to the Appler attacks on the St. James Church and Heidelberg Tavern situated in Cape Town. You confirm that instruction?
I do, sir.
Okay. So in February of 2004, you had instructed the DSO to investigate those 6 matters in total.
That's correct.
Yeah. All right, so at that point in early 2004, you were then had an expectation that those 6 matters would be taken forward by the DSO.
That's correct.
Now, let's turn back to your statement. And at paragraph 41, you've repeated what you've said here in your evidence. At no stage did I receive, tolerate, or act on any instruction designed to shield any individual, organisation, or political actor from lawful prosecution. And the rest of the paragraph deals with sticking to your constitutional mandate. And one of the reasons why we wanted to cross-examine you was to put to you that there were certain developments that had taken place while you were NDPP. Now, we're not suggesting that anybody picked up the phone to tell you to stop. That's not the allegation. But we are saying that while you were NDPP, there were other developments taking place, which we would want to suggest amounted to at least an initiation of steps to curtail or control the pursuit of the TRC cases. And now I'd like to take you through those.
All right. Let's hear you say.
So let's then turn to the reference in the Kalata affidavit to the Amnesty Task Team. It's on page 33. And here we're going to be relying on various documents. I'll just indicate up front what they are. They're the original terms of reference of the Amnesty Task Team, and that's at page 200. We will also be relying on the original secret report of the Amnesty Task Team in 2004. That's at page 201. And then finally, we will be relying on the secret further report of the Amnesty Task Team, and that's at page 213. So if we can perhaps start with the terms of reference, that's at page 200. So let's just, luckily there are not too many paragraphs here. So the terms of reference, at least those that were attached to Ackerman's, at least Advocate McAdam's affidavit, says that the terms of reference are the criteria the NPA applies in deciding on current and impending prosecution of cases flowing from the conflicts of the past, the formulation of guidelines that will inform current, impending, and future prosecution of such cases, and bearing in mind the above-mentioned guidelines, whether legislative enactments were required, and whether any of the 2 bills that have already been formulated can be taken forward while taking into account the views of the intelligence agencies. So I just want to put it to you that, for example, that very first term of reference, the criteria the NPA applies in deciding on current and impending prosecution of those cases, let's call them the TRC cases, the formulation of guidelines to deal with the prosecution of those cases. Would you agree that the terms of reference are in fact demarcating or proposing possible special treatment or different treatment of those cases?
Yes, they do.
So then if we move on, now there is a reference to two bills. The terms of reference don't explain or don't give the names of those bills, although we think that one of them was the indemnity bill. Advocate Ackerman only attached the cover and the preamble of that bill, and that's at page 154 of your bundle. Perhaps you can just look at the long title of that bill. It's on the next page, 155. To provide for the granting of indemnity by the President to persons who make full disclosure of all relevant facts relating to acts associated with a political objective committed in the course of the conflicts of the past. Gives the dates. For the said purpose, to establish a committee on indemnity to consider investigate applications for indemnity and to make recommendations to the President and to provide for matters connected therewith. Were you aware of this, what might be a draft indemnity bill at that time?
No.
And when they made reference to
And also, just to make it clear, that I was not a party to those terms of reference.
Yes, indeed, and we're aware of that. So the reference in the terms of reference to two bills, and we're speculating that the indemnity bill might be one of them. Would you have any idea what the other bill might have been?
No idea.
And then if we turn to the to the Amnesty Task Team itself, and that's on page 202, there's a report, a secret report of the Amnesty Task Team. Now, it's undated. However, if we look at the next report, the further secret report of the Amnesty Task Team on page 214, at paragraph 1.1, it says, on 3rd March 2004, the Amnesty Task Team submitted a report to the heads of Department Forum for consideration. So I think we can assume that it's likely that the first report of the Amnesty Task Team was delivered on that day, the 3rd of March 2004. And I want to draw your attention to paragraph 1.2. The task team comprises the following members. Dion Rudman as chairperson, he was from Department of Justice. Yvonne Mabula.
Sorry, where are you?
Oh, sorry, I'm at page 202.
202, sorry. Yeah. Right.
And we're looking at paragraph 1.2, the composition of the task team. Dion Rudman, chairperson, Department of Justice. Yvonne Mabula, National Intelligence Agency. Vincent Mokachane, National Intelligence Agency. Gerard Nel, NPA. Lungiso Deosi, NPA. Ray Lala, SAPS. And Joy Rateba, Department of Defense. So you can see that two of the members of the Amnesty Task Team, at least at that time, were NPA members.
That's correct.
Yeah. Now, you had mentioned that you had received a report, or perhaps you had met with Gerard Nel and Lungisa Diyosi following their first meeting.
That's correct.
And you'll see that the first meeting from paragraph 1.3 at the bottom of the page, the task team met for the first time on 26 February 2004 and again on 1st of March 2004.
Sure.
So it does seem as if those two NPA members were present at both those meetings and then were party to this report.
As far as I know, they did not attend the second meeting.
They did not attend the second
No.
meeting. Okay.
My instructions were very clear that they should not participate any further in the amnesty task team.
Right. Is there a possibility that they might have attended anyway?
I don't know.
Okay.
I would. It's possible human beings can
Yes.
can act contrary to instructions, but my instructions were very clear.
Yes.
In fact,
So-
not just my instructions, it was a considered view of us in the NPA that it would be unwise for us to participate in that forum
Right.
for reasons that I also mentioned earlier.
Okay.
That we thought that some of the people who were participating in this thing, some of the DGs, for example, that it may well be that they may be implicated in the investigation that was being conducted into the ANC 37. And so for us to participate, therefore, in that forum would have caused a conflict.
Yes. And of course, you make reference to the Directors General Forum, and it was that forum that actually established this task team, the amnesty task team.
That's correct.
Okay, can you just help us to put the searchlight on, if at all you gave your directive in writing, if you could refer it to us.
No.
I may have missed it.
No, it was not in writing. They gave a report, an oral report, and we discussed it in the office, who agreed that we are not going to participate.
Oh,
That was it.
you are not worried that you give them such pertinent instructions and they might come and say, but you didn't.
No,
and then you could refer them
No, Commissioner.
to the directive, the written directive.
No, I was working with loyal and trusted people.
Okay, thank you.
And perhaps if we just rewind a little bit, am I correct in saying that it was a Directors General Forum chaired by the then DG of Department of Justice, Advocate Vusi Pakoli, who instructed the setting up of this amnesty task team?
Yes.
And reference is made to that in the Kalata affidavit at paragraph 148. It reads, a Directors General Forum chaired by Advocate Pakoli, the then Director General of the DOJ, met on 23 February 2004 to consider how to give effect to the President's objectives set out in his speech the year before. So that gives the context for the establishment of the amnesty task team. So you have set out your concerns and why you withdrew the NPA from this body. Would I be correct in saying that you had reservations about effectively an executive body meeting to discuss matters that were exclusively the purview of the NPA?
That's correct.
Explain that. What made you uncomfortable?
Because they were discussing the criteria that should be applied in deciding who should be prosecuted or not.
And that was
And that is the
NPA's.
exclusive domain of the NPA.
Was that made clear to them? Can you recall?
No, I didn't participate in that. So those are the reasons for us to pull out.
Okay.
And already by then you had a set of criteria that was developed by the HRIU, the Human Rights Investigation Unit.
Yes.
And would it be correct in saying that those criteria were consistent with the existing prosecution policy?
Correct.
So perhaps I'll aside from the composition of the DG's forum and the Amnesty Task Team, let's look at some of the functions of the proposed departmental task team. It's an overview of that is given in from paragraph 156 onwards, but it's also set out at 206 from paragraph 3.2.2, where it's...
Can you bear with me, sir? I need to fix my bundle.
Yes, of course.
It's falling apart.
Maybe somebody can assist you with that?
No, it won't be necessary.
Sure.
You were saying page?
So it's page 206 of that bundle. So we're now a few pages into the report of the Amnesty Task Team. And at the bottom of page 206, it's paragraph 3.2.2.
All right. Got it.
Yes. And my attorney just advises me to highlight the preceding paragraph. It's titled, Add Paragraph 1 of Terms of Reference, in order to give effect to the arrangements contemplated in the President's statement as reflected in paragraph 1 of the Terms of Reference. And you recall that was the developing criteria for these cases. So under 3222, or hold on, before we get there, so they recommend that a further body be created, and that's set out in 321. It's called a departmental task team. At a later stage, it's also called the interdepartmental task team. It's recommended that a departmental task team be appointed comprising members of the following departments or institutions. First is the Department of Justice, intelligence agencies, South African National Defence Force, South African Police Service, Correctional Services, National Prosecuting Authority, and Office of the President. And then we turn to the functions at 322. Before the institution of any criminal proceedings for an offence committed during the conflict of the past, to consider the advisability of the institution of such criminal proceedings and make recommendations to the NDPP in this regard. Firstly, your response to the creation of a departmental task team comprising those individuals, several members of the executive, including the Office of the President, and that one of their functions would be to advise the NDPP on the advisability of instituting criminal proceedings in these cases.
That would have been wrong. Unless, of course, we have no confidence in your national director.
All right. Aside from that fact, which I'm sure wasn't the case, but why would it have been wrong?
Precisely for the reasons I'm saying. That the decision whether to prosecute when to prosecute, what to prosecute for, are all prerogatives of the National Prosecuting Authority. Now you want to fetter that discretion, so why do you need to have an independent institution?
And then if we move to the next page, that's 207, paragraph B, to consider applications received from convicted persons alleging that they have been convicted of political offences with a view to making recommendations for their parole or pardon, and in making such recommendations to consider various criteria. And then those criteria are then listed in the subparagraphs that follow. They include the amnesty criteria from paragraph D. Those are the amnesty criteria which we're all familiar with, so we won't need to deal with those. And then on the next page, 208, there's a range of proposed criteria. And I'm not going to go through all of them, but it does include whether prosecution politically reflects the aims of the TRC Act and is not in conflict with the requirements of objectivity, whether there are humanitarian concerns, whether prosecution could lead to conflict and traumatization of victims, the perpetrator's sensitivity to the need for restitution, the degree of remorse shown by the offender and his attitude towards reconciliation, the degree of indoctrination to which an alleged offender was subjected, the extent to which the perpetrator carried out instructions, whether he or she renunciates violence and a willingness to abide by the Constitution. And there are others. We don't have to go through every single one of them. What is your reaction to the proposal that a number of additional criteria, like the ones I've highlighted, are being proposed for these cases?
Well, remember this. At the time when this was, I was not there. So you're just asking me for my opinion.
Yes, indeed, just your opinion.
Well, as I have stated already, I thought that those are matters that should have been left to the discretion of the National Director. I didn't see the need for that to happen.
Right.
Mr. Vani, can I
Yes.
interrupt you? On these cases, can you think of any reason why the National Intelligence Agency would be involved, would want to be involved? I'm trying to understand that. I'm hoping you can help.
I would imagine that it was from state security angle, that these people would have given information which would have been very important for the national intelligence agencies in the work that they do in protecting the state. So I would imagine, therefore, the thinking was that if these people would go and give information, credible information, which would be of assistance in the intelligence work.
Yeah. Thank you.
So that would have been the reason for the inclusion of Ms. Yvonne Mabule?
Yes. I would imagine so, Commissioner.
Yes, I see, because I see opposite her name, National Intelligence Agency. Thank you.
And then if we can just highlight a few other issues that the task team alluded to. We can turn to page 210, paragraph 3.2.4. It says the task team realizes that the proposed process will have the following shortcomings / concerns. A possible negation of the constitutional rights of victims, the public at large, and alleged offenders. Do you agree that the proposal could have impacted the constitutional rights of victims and the public?
Could have.
And then they say the possibility of the institution of private prosecutions. So here it seems what they're trying to say is, well, if we implement this, it potentially somebody aggrieved could still try to bring a private prosecution.
That's correct.
And does that indicate to you that the underlying end goal was actually to curtail all prosecutions?
I'm not sure. I don't know.
Okay. All right. Let's then turn to the secret further report of the Amnesty Task Team. That's at page 213. So I want to draw your attention to paragraph 1.2. As we've indicated, it makes reference in 1.1 to the first report, which was delivered on 3rd of March 2004. And then the heads of department discussed the report with members of the task team, whereafter they deliberated the task team's proposals and recommendations in camera. Following these deliberations, the heads of department indicated that they prefer the task team's recommendations relating to the establishment of a departmental task team. They, however, requested the task team to give further consideration to the following aspects. And I want to highlight paragraph B. Consider whether there is a way in which private prosecution and civil litigation can be eliminated if the NDPP decides not to prosecute. Investigate the possibility and desirability of legislation if required. So the DG's forum or the heads of departments, they make this remarkable request. Is there a way of eliminating private prosecutions and civil litigations in respect to the TRC cases? And if so, do we need a law? What does that say to you about their intentions?
It's you're putting me on a spot because I did not participate in their deliberations, and so I don't know what motivated them to come to that. But reading between the lines, you could see that they wanted to bring about finality. So there should be no private prosecutions, no approach to the international court, and that the matter must be brought to an end, and that there must be closure. That's what seems to stick out to me from these paragraphs that you have read.
And that does not put you on the spot, sir.
I'm sorry. Sorry, Commissioner.
I think, Advocate Ngcuka, it might go a bit further than that. If it was closure and finality, well, then I suppose we would want to see prosecutions expedited as quickly as possible. But our reading of it is that it goes further than that. One, they're proposing a process in which they would have some involvement, at least, in the decisions of the NDPP. but they're also looking at ways of stopping matters that would be beyond their control. And so private prosecution and civil litigation, that's potentially beyond their control. So now they're saying, are there ways of eliminating those two measures? And if so, we need a law. So it seems as if it's not just a question of reaching closure, it's a question of stopping those kinds of measures which could be pursued without their involvement.
In other words,
it could well be
denying
so.
rights.
Sorry, ma'am.
I'm sorry, I interrupted you.
Sorry, go ahead, Commissioner.
In other words, denying whatever rights might be available to the citizens, affected citizens.
It could well be so.
Would you agree with that?
It could well be so.
And then let's look at the next two paragraphs. The proposed task team should work under the direct supervision of an interministerial committee. And it is important, and then paragraph D, it is important that the proposed task team, the interministerial committee, and the national director, in performing their functions and reaching decisions, should take the national interest into account. So one, they're saying the task team in turn must be directly supervised by the interministerial committee, and then all these bodies, the task team itself, the interministerial committee, and the NDPP, when dealing with these cases, must take the national interest into account. What, in your view, and again I'm only asking for your opinion, what would that national interest be?
Well, if it was probably the decision would have led to public violence and caused massive uprising in the country, you know, I don't know. That's what I think.
All right. Well, I think that's probably debatable, but let's move on. And I want to make a reference to the fact that they approached the state law advisors. We'll just find the reference there, 215. And actually, before we move on, and just to finish off on 214, paragraph E, advise the forum on whether a person who is aggrieved by a decision of the national director may approach the International Criminal Court. So would you agree that they were concerned that even if they managed to curtail prosecutions at a local level, there might be a danger that an aggrieved person may go international to the ICC?
Yes.
Yeah. And then if we can move to page 215, it's at paragraph 2.4. And that's dealing with the establishment of an interministerial committee. The task team supports this proposal. However, it wishes to point out that the state law advisors are of the view that the establishment of such a further structure may constitute a cumbersome process and increase the possibility of conflicting views between the various role players and structures. Furthermore, they pointed out that the process might be seen as an attempt by the government to put undue pressure on the NDPP in reaching an independent decision. Would you agree with the opinion of the state law advisor?
Yes.
So, just to wrap up the work of this amnesty task team, And of course, we speak with the provisor. We know that you were not involved, and it is your evidence that you pulled your NPA members from that task team, and we've heard your evidence in relation to it. So bearing that in mind, which we accept, nonetheless, while you were NDPP, there was this outside body in the form of the DG's Forum and this Amnesty Task Team that were putting together proposals to effectively ensure a measure of control over the TRC cases. Do you at least accept that was happening, and that was that constituted an attempt to undermine the independence of the NPA?
I'm not sure. I know there were attempts. I'm not sure if that was the intention. I think that what they were trying to do was to resolve what they considered to be a problem that they had. But the method in which they went about it, I think it was, or the result that came out of it was incorrect. And so, yeah.
Yes. Well, I think you might be being a little generous, but let's leave it at that. And we are going to, in fact, turn to the actual amendments that were introduced later, following your departure from the NPA, to see what was the result of the work of these bodies. But Commissioners, I see it's almost lunchtime. Would this be an appropriate time to take the lunch
Yes.
adjournment? Yeah.
How long are you going to be with Advocate Ngcuka, Mr. Vani, if we may just get an indication?
If I were to guess, I would think about an hour.
About an hour.
Yeah.
We'll take a lunch adjournment until 2 o'clock.
As the Commission pleases.
Mr. Vani?
As the chairperson pleases. Mr. Ngcuka, just before we adjourned for lunch, we had wrapped up a discussion on the work of the Amnesty Task Team and the various proposals that they had made.
Yes, sir.
Great. You can hear me?
Yes, I can.
Great.
Thank you.
And just before lunch, I said I would make reference in passing to what the outcome of their deliberations were.
Yes.
One of the main products that emerged were in fact the amendments to the prosecution policy, and I just want to refer you to it. Unfortunately, it's not in that new bundle, but it is in bundle 1 that I believe is on your desk. The amended prosecution policy is at page 634 of bundle 1. Sorry, I beg your pardon, page 537 of bundle 1. It says FA 27 in the corner as well. So bundle 1 would be the...
Bundle 1 of 1 is, for me, it's up to page 300.
Page 537.
So let me check on this one. Yeah. 537.
Yes.
Got it.
And is that the one that says FA 27 and then it says Appendix A?
Appendix A, correct.
Yes, okay. So those are the amendments to the prosecution policy in relation to the TRC cases. And I'll just draw your attention, if you could turn to page 539. And then at the bottom of the page, there's a paragraph 6. And this falls under Part B, which is titled Procedural Arrangements which must be adhered to in the prosecution process in respect of crimes arising from conflicts of the past. And you'll see in paragraph 6, the PCLU shall be assisted in the execution of its duties by a senior designated official from the following state departments or other components of the NPA. And then those organizations we're familiar with, National Intelligence Agency, Detective Division, SAPS, Department of Justice, and Directorate of Special Operations. And we know from the evidence of Anton Ackerman, as well as other documentation that is before the Commission, that another task team, sometimes referred to as the interdepartmental task team, was set up, comprising those individuals as well as sometimes individuals from other departments. And then if I can draw your attention to Part C on the next page, it's page 540, and that's titled Criteria Governing the Decision to Prosecute or Not to Prosecute in Cases Relating to Conflicts of the Past. And it says, apart from the general criteria set out in paragraph 4 of the prosecution policy, that being the existing policy, the following criteria determined for the prosecution of cases arising from the past. And if we go to the next page, that's page 541, you'll see that many of the proposals suggested by the Amnesty Task Team are included. So, for example, the TRC criteria at the top of the page. And then if we look at around the middle of the page, D, under personal circumstances, it includes humanitarian considerations, the offender's sensitivity to the need for restitution, degree of remorse shown, attitude towards reconciliation, renunciation of violence, a willingness to abide by the Constitution, degree of indoctrination to which the offender was subjected, Then at F, the extent to which prosecution or non-prosecution will facilitate or undermine the national project of nation building through transformation and reconciliation and so on. And then the last, there's even a catch-all criteria at the next page, 542 at J. Any further criteria which might be deemed necessary by the prosecuting authority for reaching a decision. So do you agree that you can see quite a big overlap between what was proposed by the Amnesty Task Team and what was ultimately proclaimed in the amendments to the prosecution policy?
Yes, I do see that.
Yeah. And again, this is not a criticism of you, but you accept that what has happened here with the amendments is that a different regime has been set up in relation to prosecution decision-making in relation to that category of cases.
Yes.
Then we just want to deal with a few matters that arose this morning before we proceed. And I want to direct your attention again to those two declarations in which you identified 4 cases and then another 2 cases.
Sure.
And the instruction was that the DSO should investigate those cases. So my first inquiry is any reason why you were not able to, or you decided not to issue a declaration that the DSO investigate all the TRC cases?
I'm trying to think why. I suppose that was the advice I received from the people who are involved, that those are the ones that they wanted to deal with at that particular point in time.
Okay. And then just looking at the 6 cases, we obviously were interested to see what had happened to them, and some of them they're quite well known, so we do know what happened. So, for example, the PEPCO 3 that got quite a lot of publicity. There was a review of the amnesty decision, and then unfortunately that stalled. But that was all post your term.
Yes.
In relation to the Chikani matter, there we know that one went ahead. There was a plea and sentence agreement. But I want to, and that took place in 2007, again post your term. But I want to draw your attention to a reference that McAdam made to the investigation of that case, and that's at page 93 of the new bundle in his affidavit. So we can abandon bundle 1 for the moment and go back to the new bundle. Sorry, it's at page 93. And it's at paragraph 26 of his affidavit. I'm told that the live stream is not running. Is there a way of repairing that? Anyway, I'm sure the technicians will deal with that. So paragraph 26 at the bottom of page 93, McAdam says, at a certain stage, Ackerman informed me that he intended prosecuting 3 former security branch members for their role in the poisoning of Reverend Frank Chikani. This was because all the evidence implicating them had already been led in the prosecution of Wouter Basson, and no further investigations were necessary. And we heard that evidence also from Ackerman, so they appear to be saying that in that case, it didn't need to be investigated. It was already investigated in the Wouter Basson case.
Yes.
Then if we turn to the Motherwell 4 case, that was a little more difficult to get to the bottom of, but we did establish that there had been convictions of certain accused in 1996, and that there were applications by 9 applicants in 1999, and this included people such as Gideon Nieuwoud, Bernard du Toit. You're probably familiar with those names.
Yes, I am.
And they were all refused. And then it looks like du Toit went to court to review the refusal, and it looks like the court ordered the reinstatement of the Amnesty Committee. And from what we can establish, du Toit was granted amnesty in 2005. Nieuwoud was refused. That's all we were able to find out on that case. In relation to Ngcuka, and that was an investigation against. Yeah. So the suspects there were General Engelbrecht and General Nick van Rensburg. Unfortunately, we haven't been able to find anything. We searched high and low, so it's not clear whether that investigation proceeded or not, and if so, what the outcome was. And then lastly, the investigation that you directed to happen in relation to the massacres that took place at various hotels in the Western Cape, St. James, and I don't have the other one with me right now, but I'd like to refer you to page 150 of the new bundle. It was the St. James Hotel and the Heidelberg Tavern.
Yeah, correct.
Yeah. So there is a report on that case in a document that commences at page 142. And it's prepared by Advocate Ackerman. It's directed to Dr. Ms. Ramaite. Subject is audit of cases emanating from the TRC process. Date is 24 October 2006. So some years after you had left.
Yes.
And at page 150, at the bottom of that page.
Page of? Page?
So it's 150 of the same bundle.
Okay. I'm with you.
So Ackerman is now reporting to Ramaite about progress in various cases. And he then deals with the Heidelberg Tavern and St. James massacres at 411 Letlapa Mshlashlela, and then he refers to the two places. And I'll just skip to paragraph 411.3. As soon as an investigator is appointed for the case, a decision will be made on whether to prosecute or not. So on the face of it, from that statement, it may be that an investigator was not appointed to that particular case, because the allegation is that in 2006 they were waiting for an investigator to be appointed. Anyway, so I just wanted to let you have the outcome of those 6 cases, something of a mixed bag. And in fact, I suppose the only real successful outcome was that of Chikani. Anyway, let's move on. And I want to refer. Hold on. Before we go any further, I reminded myself that there might be a few things arriving from your evidence in chief, and there are just a couple of short ones. In the late 1990s, during your oral testimony, you made reference to the fact that in relation to a number of, I suppose, priority crimes, for example, political violence in KZN around Richmond, you decided to bring investigators, prosecutors and analysts under one roof, and that the investigations in the KZN Midlands were very successful.
Correct.
I have the same recollection, being from KZN myself.
Yeah.
Would I be right in saying that most of those investigated, prosecuted, and I know there were several convictions as well, that most of those were actually of ANC members?
That's correct.
Yes. Because there has been an allegation put up or suggested by organisations such as AfriForum that post-1994 there were few, if any, cases against organisations such as the ANC. Would you agree those investigations and convictions suggest otherwise?
Indeed.
In your evidence in chief, you highlighted the Biko case, Steve Biko, who died in detention. You said you wanted to take that case ahead, but you didn't have sufficient evidence, and that if you had gone ahead, they would have been acquitted. Now the Biko family would like more information, and if you and your team are in possession of any reports, documents or opinions relating to the Biko matter, would you be willing to disclose those to the family?
Oh, certainly. But unfortunately, I no longer have. But I think what I can do is to make them contact Vincent and Chris Macadam, people who reviewed those files.
Thank you. I do recall a reference, and I forget where it is, maybe my team can help me, where it mentioned that the crimes had prescribed.
That's correct. The culpable homicide ones had prescribed.
Culpable homicide?
Yes.
Although presumably murder itself, that doesn't prescribe.
Yes, that's the one we could not succeed in prosecuting.
Okay.
Because the evidence wasn't sufficient. I think you'll find in one of the bundles there's reference made to that. I don't know whether, I think it will be Chris Macadam's report. I can't remember exactly where it is, where he states categorically, these are the challenges. There was only one doctor who remained, and there were problems with his evidence. I think it's in one of the bundles. I can't recall which one. But I think it will be in one of the reports that was submitted to me.
Okay. So in one of the Macadam...
You couldn't call Ms. Helen Zille to give evidence in the Biko matter.
Sorry, Commissioner, I didn't get you.
I say in the Biko matter, you couldn't call Ms. Helen Zille to give evidence.
Unfortunately, she didn't have any evidence credible evidence that we could rely on.
Yes. Okay.
So we have found a reference in one of the documents, I think one prepared by Macadam. It's at page 105 of the bundle, and It's from, yes, it's from McAdam to the deputy head of the DSO, copy to Leesk, and he, at page 105, he says Steve Biko, crime prescribed in 1997. And I think there are also some other references which we'll look at. And but if there is any information that you and your team have that could assist the Biko family.
I don't have any independent information other than what I received from the team.
Thank you. And then also in your evidence in chief, in a similar vein, you outlined the various practical and evidential challenges of pursuing, I suppose we could call them old cases or cold cases. And I think investigators and lawyers are familiar that the older the case, the more difficult it becomes to investigate.
Yes.
So we certainly recognise that, and but we want to put it to you that yes, they are difficult. It's difficult to find witnesses who are alive and who can testify. It's difficult to find documents, but we want to put it to you that with the help of thorough, rigorous investigation, and particularly forensic investigation, even cold cases can be solved many years later, sometimes even decades later.
That's true.
So, for example, the Ahmed Timol case before the reopened inquest in 2017, that case managed to be resolved. Same with the Neil Agate case, which was before an inquest in 2021. The Hussein Hafaji matter and the Imam Harun matter, which were also held in recent years, and all those inquests managed to get to the bottom of what happened to those detainees.
Yeah, I agree with you.
And then lastly, from your evidence in chief, you were giving some numbers of investigators, lawyers, and accountants, and I just wanted to check. I was assuming that you were talking about the DSO. Just to remind you, you mentioned 300 investigators, 55 lawyers, and 5 accountants. Was that the rough staff complement of the DSO?
Approximately, yes.
Okay. If we can then... Well, perhaps we can deal with this now, since my attorney has drawn it to my attention, and we'll just have to quickly go back to President Mbeki's speech, and it is the sentence in question I've already read to you. So I'll just read the one sentence again. However, as part of this process and in the national interest, the National Directorate of Public Prosecutions, working with our intelligence agencies, will leave its doors open for those who are prepared to divulge information at their disposal and to cooperate in unearthing the truth, and so on. Now, the reference to intelligence agencies, did you have an idea of what the President had in mind? Or did you perhaps approach him to find out?
No, I didn't.
Okay.
No, I didn't. I suppose it speaks to the issue that was raised by the Commissioner before lunch. Why would you involve the national intelligence? In some of the difficult cases that I dealt with, we relied on the intelligence that we received from them, which were then able to convert into evidence. So I would imagine that is the reason why the President was referring to.
Yes, indeed. And I suppose the NPA is entitled to gather evidence from wherever, leads and the like. So if it's simply
Yes,
a question of the intelligence agencies helping with the investigation, giving you
with the
facts.
investigation.
Yeah. So that would be no issue. Although, as we've seen from subsequent developments, it went further than that. It wasn't just a question of handing over information. It was sitting on committees. Anyway, we've dealt with that. We won't go down that particular road.
Sure.
But perhaps I think what I will do, though, is quote what McAdam said in relation to the role of the NIA on those committees. And we'll just find it. That is part of the bundle, the McAdam affidavit. So we just have to find that, if you bear with us. Okay, so it's on page 94. And here he's referring to that task team that got created after the amendments were put in place. It's on page 94 at paragraph 30. He says, Advocate Pikoli was appointed as the NDPP. I was informed by Ackerman that Pikoli had set up an interdepartmental task team that would advise Pikoli on making decisions in TRC matters. Ackerman and Ramaita were the NPA representatives on the task team. On one or two occasions, I stood in for Ackerman in meetings on the task team when he was not available. I noticed that the task team was predominantly comprised of members of the intelligence community who were more intent on cross-examining me as to why matters should be investigated rather than addressing the issue of all the outstanding cases. So from McAdam's perspective, he wasn't getting support. They were intent on establishing why McAdam wanted to go ahead with these cases.
This probably would strengthen the decision that we took earlier.
Yes.
Not to participate in that forum.
Yes, indeed.
If this is what happened to Chris McAdam.
It certainly reinforces that decision. And while we're on McAdam, I'll just put one last paragraph to you. It's on page 98, at paragraph 47, at the bottom of the page. And this is, on the question of investigations. McAdam spends a few pages setting out the attempts he and Ackerman made to get investigations on the TRC cases. And so his penultimate paragraph, he says, these documents speak for themselves and go a long way in explaining why from 2003 the PCLU constantly struggled to have TRC cases investigated. So he seems to be confirming that some years later, towards 2009, 2010, they were still battling to get investigators onto these cases, but again, post your term.
Yes.
All right, then let's move to an internal memo that's at page 267 of this new bundle. And this is a secret internal memo that Advocate Ackerman addressed to Advocate Pikoli, who was then NDPP. It's dated the 16th of May 2006. And the subject is National Intelligence Agency incidents. And if I can draw your attention to paragraphs 13 and 14 at page 271, because your name appears. So I'll just read these into the record and then you can respond to them.
Is it paragraph 13?
Yeah, I'll start reading at 13 just to give it a bit of context.
Just a minute.
It's at page 271.
Thank you. Got it.
Okay. Due to the difficulties encountered with the DSO, my 2 deputies and I met with Commissioner Lala to inform him of my unit's mandate and to request him to channel any intelligence relating to the cases to my unit. During the course of these discussions, I did express my dissatisfaction with the DSO and informed him of the allegations being made against the President. McAdam also asked his assistance concerning the Motherwell case, where the accused were alleging that the deceased had been killed because they were MK operatives. As I subsequently discovered, this conversation was clandestinely recorded, both on audio and video. Just so you know, this meeting took place in August of 2003. And then in paragraph 14, at a later stage, my 2 deputies and I were at short notice summoned to a meeting with Mr. Ngcuka. Mr. Ngcuka informed me that Commissioner Selebi had addressed a meeting of the Directors General and alleged that Mr. Ngcuka was preparing to have the President and 6 generals arrested and charged with terrorism. Mr. Ngcuka further informed me that Commissioner Selebi was in possession of a video recording in which I had admitted that the President was due to be arrested. I was then shown the video recording of my meeting with Commissioner Lala, and this is how I learned that the meeting had been recorded. Perhaps let's also do, since it's connected, we'll do 15 as well. Mr. Ngcuka further informed me that Commissioner Selebi had complained about the NPA being in possession of SAPS dockets. Apparently the allegation was that these dockets contained the evidence that would be used to prosecute the President and other high-profile ANC leaders. I denied the existence of both an attempt to arrest the President and others, as well as the existence of the so-called relevant police dockets against them. Mr. Ngcuka then made arrangements for you and the 3 police commissioners to be present at Advocate Mshe's office the next day for an inspection of the dockets to be carried out. Do you recall any of these developments?
Yes, I do.
And is this roughly an accurate portrayal of what transpired?
Yes.
No.
You want me to comment on it?
If you can offer comment, then please go ahead.
No, indeed, it is true. What Anthony says is true.
Right.
And I heard him testify that I was quite annoyed with him. That indeed is an understatement. I was angry. These things happened in August. And you'll recall that I earlier testified about the period, what we were going through during that period. And for Anton to go and badmouth us to the police who were refusing at that time to cooperate with us, I found that to have been an act of betrayal. And so the people who had gone to see the video and some of my guys in the office were very angry, and just like me, and wanted us to take disciplinary action against Anton. I said no. People must be allowed to gossip about their leaders. And you too. I'm sure you do gossip about me when you sit in ship-ins with your friends. I did not hire Anton to love me. And he must continue as long as he does the good work. I'm not going to take any action against him. And that's why he remained there. I had good respect for him. And as far as I'm concerned, my attitude never changed to him because he did that. That's it.
Indeed, it was Advocate Ackerman's evidence before this commission that he was very lucky not to have been suspended. On the question of the clandestine recording of that meeting, did you take that up with Commissioner Selebi?
Oh, no. No, not at all. We knew these are the things that were happening. These are the attacks that were directed to, to the organization. It would have been futile to go and talk to him about something that I knew he knew about. So, no.
Okay. Then let's carry on. I think we're going to go up to paragraph 18. So paragraph 16.
Sorry. I closed my page.
Oh, you close it. No,
we're
no
at
problem.
page 260.
You can turn to page 272.
272. Thank you. Thank you.
So paragraph 16, Advocate Mshe's office, Mr. Ngcuka invited SAPS to identify the dockets relating to the President and others, which they were unable to do. Mr. Ngcuka then instructed the SAPS commissioners to have all the SAPS dockets removed forthwith, and for the two SAPS members working with Advocate Fick to vacate their offices at the DPP's premises. You recall that?
Correct.
In paragraph 17, shortly thereafter, Minister Maduna personally visited Mr. Ngcuka, myself, and McAdam, and was fully briefed on all these developments. McAdam had compiled a report to Mr. Ngcuka in which he had expressed the opinion that, having perused all the relevant TRC material, there was no case against the President or the other prominent ANC members who had been refused amnesty. A copy of the report is attached here too. Unfortunately, it's not attached to our version. Minister Maduna also satisfied himself and said that the allegations made by Commissioner Salebi were untrue and undertook to inform the President accordingly. Do you have a recollection of that?
Yes, I do. It's correct.
And then paragraph 18. While I was absent from the office, I was informed by McAdam that Mr. Ngcuka had summoned him to a meeting with Mr. Billy Masetla. I believe at that time Mr. Masetla was the DG of National Intelligence.
That's correct.
I was further informed that the purpose of the meeting was to satisfy the office of the President that there was no intention to prosecute the President. McAdam finally advised me that he had given Masetla a copy of his report and that he was satisfied with the manner in which the matter had been dealt with. Is that correct to the best of your recollection?
That's absolutely correct.
Yeah. Now, again, we're dealing with events post your term of office, but did you then get to hear about the forged letter that Ackerman discovered had been put up in his name?
No, I wasn't aware of the letter. I just saw it in the bundles. I had never been told about it. That happened after my time.
Yes, it happened after your time. In 2006, according to Advocate McAdam, this letter was forged to suggest that he was about to go ahead with the arrests or prosecutions of the ANC leaders. Did you get to hear about that?
No.
No. Okay. Can we then turn to a few pages from your book? The book is part of the bundle at page 227. It's titled Bulelani Ngcuka, The Sting in the Tail. The author is Marion Sparg. I just want to put a passage to you halfway down the page. And this is at the time when you had set up the working group under Vincent Saldana. And it reads, Bulelani said he was obliged by law to prosecute where there was enough evidence to make a case. But at the same time, part of him asked if it was worth it. Part of him wanted to go for them. But another part asked whether these apartheid perpetrators, many of whom were broken or about to die, were really a threat to society. So that passage piqued our attention, because in your evidence in chief, you made it clear that you did want to go,
Of course.
after these perpetrators.
Of course.
So can I have your response to the passage in the Mandiwina book that at the same time you were asking whether it was worth it, that these apartheid perpetrators, many who were broken about to die, were really a threat to society?
Yes, that's true. These are some of the things that went through my mind at the time. We're thinking about it. Wanted to go for them, really did. But at the same time, there was this nagging at the back of my head. Should we spend the mega resources that we have going for these people who are already old, who might die during the prosecution or shortly thereafter? What do we do? But at the end of the day, I said, no, let's go ahead. Let there be accountability, and let's follow what the law is. Of course, I had those doubts in my head.
And on that score, I'm sure you appreciate that, for the families attempting to still pursue justice at this late stage. Perpetrators have died. Many are ill, unable to appear in court. And some, of course, end up dying just before they can make their appearance.
Indeed. Indeed. I think those were the concerns that I had.
Yeah. Although from the perspective of the families, you had those concerns in the late 1990s. And here we are, some 25 years later, even more years later, and the families are still wishing to pursue, and the challenges they're facing are even greater, because with the passage of time, there would be fewer and fewer suspects and witnesses left.
Certainly. But as you would know, at no point in time did I tell my people that they mustn't do these cases because of what I was thinking. So it did not influence whatever the guys were doing, all those doubts that I had in my head. And I would never have acted without consulting the victims, whatever decision I may have taken at the end of the case. It would have been a matter that would have involved consultations with the victims.
Thank you, Mr. Ngcuka. I'm just looking at whether there's anything else we need to perhaps I can draw attention to 229, and I'd like to read the bottom two paragraphs to you. In 2006, an insider noted that the unit's ability to handle TRC cases was severely hampered by a standoff between the Scorpions and the SAPs about who was going to investigate the cases, and said that this matter had not been resolved at the time Bulelani resigned in August 2004. The PCLU itself didn't have any investigators. When you make reference to an insider noted, any chance you can tell us who the insider is?
No, I don't know. But the truth of the matter is what we've been discussing here.
Right.
That these were the challenges that we had at the time. The refusal to second the investigators, either from the Scorpions or from the from SAPS at the time. Those were the challenges that we had.
Yes. Then the next paragraph. After Bulelani had quit the NPA, acting NDPP Silas Ramaite called a moratorium on TRC-related cases. Bulelani's successor, Vusi Pikoli, complained later about improper interference in his work on the TRC cases and said, legally, I have reached a dead end. The failure of the NPA to prosecute TRC-related crimes remains a sore point for many families and comrades of those who died at the hands of apartheid security forces. So on that score, I just want to turn to what Silas Ramaite and Vusi Pikoli had to say. And let's start with Silas Ramaite. His statement is in this bundle from page 240. And I just want to bring to your attention a paragraph in Advocate Ramaite's statement in relation to a moratorium that got imposed on the TRC cases, again, post your term of office. So paragraph 32, I advised Advocate Ackerman SC that it would be better to wait and have a better understanding of what was happening. Just to give you the context, this was after an attempt had been made to carry out the arrests of certain suspects in the Frank Chakani matter. And what had happened is that the attorney for the suspects had gotten hold of Advocate Ackerman and asked him to not carry out the arrests. When Ackerman declined, he was then called by somebody within the Department of Justice, and then ultimately he was called by Advocate Ramaite, and he was told to not to pursue with the case at that time, pending the formulation of guidelines.
Sure.
Eventually the amendments to the prosecution policy.
Yeah.
So Ramaite says, shortly after I'd spoken with Advocate Ackerman, I received a telephone call from the Minister of Justice, Mrs. Bridget Mabandla. She told me that there's a task team which was appointed by the Directors General Forum to develop a mechanism to deal with the TRC cases. I expressed to the Minister my concern that any process or mechanism which involves the Executive or the Justice and Security Cluster would amount to encroaching in prosecutorial decision-making and would be a violation of prosecutorial independence as enshrined in Section 179 of the Constitution. The Minister nevertheless insisted that the prosecution of all TRC-related cases must be put on hold until the development and adoption of guidelines. So that's the context in which I want to put his concluding paragraphs to you to see if you agree with Advocate Ramaite. So if you could turn now to page 254. And I'm going to read those final 4 paragraphs. I regard the imposition of a moratorium by the Executive or a member of the Executive on the prosecution of TRC cases purely on the basis of developing and adopting guidelines to deal specifically with these cases as a form of political interference. 51. The development and formulation of prosecution guidelines by a committee consisting of Directors General of the Security Cluster is inconsistent with Section 1795A and B of the Constitution and Section 22(1) of the NPA Act and is unlawful. 52. I also regard the attempt to involve a body consisting of Directors General to make recommendations on who to prosecute and who not to prosecute as an encroachment into prosecutorial independence. And lastly, there is no doubt in my mind that the effective investigation and prosecution of TRC cases was severely hampered by political interference. Do you agree with the sentiments of Advocate Ramaita?
Sorry? Oh, I thought you were saying something, Commissioner.
No,
Sorry.
it was a question, do you agree with the statement of Ramaite?
Oh, no, I had something emanating from your side, Commissioner,
No.
so I thought there was something. Yeah. I said yes.
You agree with those paragraphs?
Yeah.
And then lastly, let's turn to what VC Pekoli said in an internal memorandum that he addressed to Minister Bridget Mabandla. And I believe that's I think it starts at page 256. It's a secret internal memorandum addressed by then NDPP Advocate VP Pekoli to Minister of Justice, Ms. B.S. Mabandla. The subject is prosecution of offences emanating from conflicts of the past, interpretation of prosecution policy and guidelines. It's a long memo, so I'm not going to read all of it into the record, but let's just deal with the purpose of the memorandum in paragraph 1. The purpose of this memorandum is to inform the Minister about the NPA's understanding and interpretation of the policy and guidelines relating to the prosecution of offences emanating from conflicts of the past, committed on or before 11 May 1994. Inform the Minister about the problems the NPA is experiencing in the implementation of this policy and guidelines, and then propose a way forward. So, Advocate Pekoli then, in that memorandum, he sets out in nuts and bolts fashion the history of the challenges that he had faced, as well as the PCLU. In particular, that he was expected to wait for a recommendation from the DG's forum before he could proceed with prosecution on the TRC cases. And so ultimately, under his conclusion and way forward, and this is now on page 266, he says the following, paragraph 5.2. I have now reached a point where I honestly believe that there is improper interference with my work and that I'm hindered and or obstructed from carrying out my functions on this particular matter. Legally, I have reached a dead end. It would appear that there is a general expectation on the part of the Department of Justice and Constitutional Development, SAPS and NIA, that there will be no prosecutions and that I must play along. My conscience and oath of office that I took does not allow that. Based on the above, I cannot proceed further with these TRC matters in accordance with the normal legal processes and prosecuting mandate of the NPA as originally envisaged by government. Therefore, and in view of the fact that the NPA prosecutes on behalf of the state, I'm awaiting government's direction on this matter. As a former NDPP, reading such extracts from the then NDPP, what response do you have?
You know, I hesitate to comment about decisions that were taken by the guys who followed after me, because it's going to be difficult. You don't know the circumstances under which they were operating. One is not in possession of all the full facts. And I don't want to be seen to be critical of my successors. But let me say this. I cannot find any reason why the National Director can say he does not know what to do. The law is clear. You take the decision. You prosecute. You don't ask for the advice from other people. That would have been my view. And I thought I explained this, that most of the time, you get approached by various people who want you to change your decision and want you to behave in a particular fashion. Be it politicians, be it business people, ordinary people, happens all the time. But at the end of the day, it is your decision and your decision alone. So I don't know what caused my colleague to take that decision, but at the end of the day, he should have been the one to say no. That's my view.
Well, you probably are aware that not long after that, later in the same year, he was suspended. And you might also be aware that Anton Ackerman, he was still the head of the PCLU. He was relieved of his duties in relation to the TRC cases by acting NDPP Mshere. Does that not indicate an approach that the two of them, at least that government was taking, that the two of them should not be involved in these cases?
I'm not qualified to comment on those, because indeed I don't know what were the pertinent facts which led to their suspension or to Anton being relieved of his duties. I am not aware of the facts.
Okay. All right. I'm not going to press you further on that. Just by way of clarification, he wasn't relieved of his duties generally, just in relation to the TRC cases. And then lastly, Minister Bridget Mabandla, she was appointed Minister of Justice on the 29th of April 2004, so a few months before you
Yes.
resigned from office. Did you have any discussions with her prior to your departure on the question of the prosecution of the TRC cases?
I may have, because I reported to the minister regularly, and we had a very good working relationship. So not just on the TRC cases, in my normal reports to the minister, I may have mentioned these TRC cases.
But you're unable to recollect the nature of the discussion?
No, I would have given the report about what is happening. Right. What are we doing? Where are we with these cases? Where are we with in respect of many other issues that we're dealing with?
Right. My attorney has just reminded me of one further matter. And then we promised the commissioners 1 hour, and then we will pause from our side. When I asked you somewhat earlier about, or rather I put to you what Lukanya Kalata had said in his affidavit, that in all likelihood direction was coming from a political level in relation to these cases. And your response was that that wasn't so, or that was unlikely, something to that effect.
So that was not so during my time.
Certainly not in your time.
Yes.
But would you agree that, from the perspective of SAPS, the fact that their response was that they would only investigate if the president directed them in writing, that from their perspective it had to come from a political level?
Not necessarily, sir. Not necessarily. You must remember that we had these problems of thefts between us and between the police and the Scorpions. And the police had taken a view that it wasn't necessary for the president to have established the DSO, that they were capable of doing all these cases. And so writing that note, in my view, from Commissioner DPA, was to say, go and tell the president that you do not have capacity to do these cases. And so it had nothing to do with political interference at all, in my thinking. It was purely to say, President must trust us who can do this work other than you guys.
On that score, Mr. Ngcuka, we will be submitting at the appropriate time that that was yet further evidence of the fact that at a very high political level these cases were receiving attention, and that an entity like the SAPS were not willing to get involved without that kind of political instruction. That's what we will be submitting to the Commission.
Sure.
Yeah. Mr. Ngcuka, many thanks for your time and the support that you've given this Commission.
Thank you, sir.
No further questions, Commissioners.
Thank you, Mr. Vani. You've been true to your undertaking that it will take you an hour to conclude your cross-examination. We commend you on that one.
Thank you, Commissioner.
Mr. Seminya.
Chair, I don't know if there won't be any clarificatory questions asked of the witness before I come.
No, this is cross-examination. There are no clarificatory questions allowed.
Mr. Ngcuka, good afternoon to you.
Good afternoon, sir.
You have been very emphatic within the meaning of the terms of reference that there was never any external effort or attempts at making the prosecutions of TRC cases to be stopped. I'm right, eh?
That's correct.
And we have trawled through the papers and could not see any suggestion that during your tenure any effort was done to stop the prosecution of these TRC cases that you can accept.
That's correct, sir.
There is a small area which I want to test with you, and I have listened throughout to the questions put to you on behalf of the Galata Group. For ease of reference, I have given a document that is A15, which is supposed to be a media release.
Just bear with me. I had it here. I must have shoved it in this file. Got it. Thanks.
All right. That purports to be an MPA media release. You would see it is dated 13 May 2004.
That's correct.
And it is on its reading issued by Sipho Ngwenya, Executive Manager, NPA Communications.
Correct.
I just want to read the first paragraph and then have a conversation with you about it.
Sure.
It reads, the National Prosecuting Authority, NPA, has decided not to launch any investigation into 37 ANC leaders who were refused amnesty by the TRC. Do you see that?
Correct.
Were you familiar with this press release at the time?
Correct.
It would have emanated from your office.
I authorized it.
You authorized it. What I did try to establish was whether that decision ever was made in writing outside this media release.
whether the decision was,
in writing.
the recommendation was in writing. It came from that unit, the PC, Anton Eckermann's unit.
Yes. But their decision itself was never in writing, if I understand Mr. McAdam. It says it was a decision that was made after they gave you a briefing.
No, they wrote a report which they sent to my office, which was accompanied by a briefing. And so the statement was then drawn out of that.
Or he might just be mistaken to think that the briefing was verbal. Well, he uses the word oral. He might be mistaken. There was something in writing.
Yes, there was a report that they've gone through all the files and they cannot find any evidence whatsoever to proceed.
Yes, I have seen.
That report was initially submitted. Makatam prepared the report and he gave it to Anton, who then confirmed it and gave it to me. And then they came to brief me about it, and we agreed that we need to release the press statement.
Both may be consistent with one another. I am alive to the fact that the advocates had written down
investigated prior to coming to my office. They were in the DPP's office in Pretoria, and there had been a thorough investigation which was done. And so what my office did was to go through the dockets which were there, and they followed up with the people who were mentioned in the dockets. I can't recall now, I think there was an entity that called Equality Before the Law, I can't remember, followed with them to say, please give us the information that you have, and others. So there was that investigation that was done, and there was not enough evidence to even declare that in terms of Section 28.
What I'm trying to establish is, would the investigations have also included things like warning statements of the 37?
I would imagine so, Counsel. But I personally, of course, read the dockets. I think Chris and Anton will be able to assist you there.
Yes, we will engage them about that. There are dockets that are said to be at Fisaki offices in Pretoria. You do not know about those, do you?
There is no office in Fisaki, as far as I know.
Well, there is a
this would have been the DPP's, either in the DPP's office or in my office.
All right.
And those dockets that were in the DPP's office are the ones that were taken over to my office.
Yes. Yeah. Okay, I will take that journey with the two advocates when they come. What could have been in those dockets to sustain the conclusion that is reflected in this media report?
Sure.
I have no further questions to you.
Thank you.
Mr. Ngcuka, I have a hypothetical question.
All right.
Given the important role that you played in our country as the NDPP, if you had taken a decision to prosecute one of these TRC matters, and subsequently the Committee of Directors General was put together to advise you after you had taken the decision to prosecute, would you, in your role, have regarded that as an effort or an attempt to influence or to pressure you to stop prosecuting?
Yeah, yes. I could have regarded it as such. But in my case, I would have listened to them.
You would have listened?
I would have
and
listened to them.
And your response to them would have been?
Thank you very much.
Goodbye.
Thank you.
Okay, thanks. You've made your position perfectly clear. Thank you.
Thank you.
Mr. Pana?
We have no questions, clarificatory or by way of re-examination.
Thank you. Mr. Ngcuka,
Commissioner.
we thank you for having availed yourself to come and give evidence before this commission, given your hectic schedule. We appreciate it. You are now excused as a witness.
Thank you. Thank you, Commissioners.
These proceedings are adjourned until tomorrow at 10 o'clock.